Monthly list of December. Wait. Yes.
Your Lordship, may I be permitted to mention a matter for inclusion? It is a new matter. It has not been heard before. Your Lordship.
Of 2025.
Of 2025. Wait.
Monthly list of December.
May I have your Lordship's kind leave to mention that this matter appeared before Justice Hon'BLE on 31st last October as item number 20 under the listed motion. After change of determination, it is not appearing. So may it appear in your Lordship's list.
Hand over the sleeve, monthly list of December.
Or secondly, for Lordship to get an application listed before Lordship.
Application for what? When the writ petition was dismissed?
Was in the July 2024. Unfortunately,
2024. Have you filed section 5?
Yes. Both the applications are.
Under the heading application, monthly list.
One matter, 2019. Amendment application has been filed and let it appear in.
19 matter, hearing matter, you have to wait. Hearing matter, I am not including now.
But the application is there.
Maybe application will appear along with the hearing. Sorry, you have to wait.
Application is
When you have filed the application?
24.
Wait. Because it is to be amended and then it is matters to be heard. Application in 2020. Have you served notice upon other side?
With notice.
Hand over the sleeve application under the heading. Hearing, no. Sorry. Wait. Yes. When assigned? Very well. Assigned matters all are brought to my notice. It will appear. Yes.
My Lord.
Arising out of the order passed by this court. Yes, Justice. Justice Tandon. Old contempt heading and they have a combined list. Yes. 18 contempt. Passed by order passed by. Old contempt diye debe.
May be permitted to mention motion. The matter was last heard by Honorable Justice Hon'BLE Roy. It was directed to appear on 20th November, but is not appearing. I'm praying for inclusion in the list. I've annexed the order.
Combined monthly list.
Lordship for new motion inclusion.
Of which year?
2025.
Combined monthly list.
Your Lordship, attention. This group 6 matter, my Lord. Now, due to the change of determination, it is now lying in court number 33. It has been brought to this court, my Lord.
33.
Court number 33.
So why it is appearing in court number 33?
So earlier it was there, determination was there, but now it has been changed.
Hearing matter or motion?
In a motion, and then
what was the last order? There was a direction for filing affidavits.
Yes, already done. Date is fixed for 12.
So hearing matter, you have to wait for some time.
No,
I'm not including any hearing matter now. Sorry. Yes.
My permanent one motion matter due to change of determination matter. Matter was appeared before Justice Hon'BLE Roy matter. New motion 2025.
Hand over the sleeve. Of which year? 2025. 2024. It has never been heard. Restoration when dismissed for default?
40/11/2000.
40/11?
Your Lordship's order matter.
My order, it relates to which group?
Group 6 one.
Group 6. Group 6 or group 2?
No, my Lord. Group 2.
I don't have determination. Sorry. Yes.
One more matter.
Yes. Next matter. Yes. Of which year? 2024. It has never been heard. Hand over the sleeve.
I was told by your Lordship to mention after fortnight.
Assigned matters will be taken up. There will be an indication. Wait for some time. Yes,
my Lord.
I know you mentioned several occasions. Assigned matters, assigned hearing matters.
Yes.
Assigned matters are coming. Assigned hearing matters. There will be indication.
Has been taken up.
Yes.
418. May I hand over the sleeve?
Yes, hand over the sleeve. There. Let me see.
My lord, this is a 2019 matter. There is a direction of the Honorable Division Bench for my lord early disposal. My lord, at your lordship's earliest.
Hearing matter.
My lord, it is in motion stage. My lord, on the last occasion, a
Show
direction
me
was-
the order of the honorable
Yes, my
division.
lord. Yes, my lord. My lord, this is the order of the single bench, Honorable Single Bench.
No, no, division bench
My
order.
lord, this is the order of the Honorable Bench.
Monthly list of December under the heading hearing.
I'm grateful, my lord.
Yes. Group 2 matter. Group 2, I do not have determination. Hand over the slip under the heading application.
May I permit to mention one matter for unlisted matter, my lord? As because, my lord, I am not getting the admit card, my lord, and my lord, 30th is the date of written examination.
Examination for?
For constable post of the West Bengal police, my lord. And my lord, the state administrative tribunal is not functioning.
30th is the date.
It is the date of written examination, my lord. And my lord, I am not getting the admit card, my lord. As because, my lord, some errors are there, my lord.
30th is the date of examination.
Only the state respondents are there.
Are you aware of why this admit card you have applied?
Yes, ma'am. It was rejected for the incomplete signature. But my lord, as because my lord, I have uploaded the full signature. In spite of that,
So why tribunal is not functioning?
I don't know, my lord. Bench is not there. My lord.
Yes.
Bench is not there. My lord.
So tomorrow urgent motion sub notice
Third notice.
upon the other state respondents is
Lordship,
Grateful,
Group 6
my lord.
matter, 2011 matter, this was lastly heard by Justice Ananya Bandyopadhyay on the 2nd of September. It was posted to 11/11 for filing of the opposition, affidavit in opposition by the opposing parties. Still not.
hearing matter. I am not including now.
Lordship, just
You have to
filing
wait.
of-
Sorry. Yes. Of which hearing? You have just mentioned one matter. You have just mentioned one matter. Sorry. Yes.
Non-prosecution.
Non-prosecution. Is it appearing in the list?
Pension paper is ready for disbursement.
Thursday to be mentioned. '24. What was the last order passed? So what you are doing for such a long time? Whether it is at the motion stage, let me see. Monthly list of January 2026 under the heading motion. Yes. (2025). No, never matter has never been heard. Monthly list of December.
My lord, may I permit to mention one matter, my lord?
My lord, may I?
Please wait. See the procedure. Don't jump upon this court. You have to wait in order to mention. Yes. Contempt application. Yes, let it appear in the monthly combined list under the heading application. Yes, 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 madam. Hearing or motion? Hearing, wait for some time. Yes. Yes, yes.
2017, heard extensively by her ladyship, the Honorable Justice Ananya Bandyopadhyay, my lord. Her ladyship heard the petition and now.
Hearing matter, you have to wait for some time. Sorry. Sorry. Yes.
May your lordship be permitted.
When I will allow hearing inclusion, I will allow everybody. Yes.
May your lordship be permitted me to mention this matter, inclusion in the daily list as a fixed item.
Yes.
As a fixed item, inclusion in the daily cost list. This is the contempt matter filed on 2025.
Contempt application arising out of the order passed by which court? Yes.
My lord, may I permit to mention one matter, my lord? My lord, new motion, my lord. Matter has been filed before the puja vacation, my lord. But till date, the matter is not in the.
Hand over the slip. December monthly list. Motion.
Matter
That's
motion
my lord.
stage, my lord. My lord, can it be inclusion in the list, my lord?
What was the last order passed?
Last order was on 12/8/2000.
Yes.
12 August 2025, my
What was the order?
lord. Order.
Ascertain and then mention. Yes.
My lord, my matter was fixed before Honorable Court number 38 before Honorable Justice Tirthankar Ghosh sir on 21st of November. I had come all the way for giving a report submission, counter report submission for police inaction. For 4 years, that same thing remain in police inaction.
What can be done? This is not the
New
regular.
determin-
This
that-
is not a regular bench.
I know that, but
Sorry. You mentioned before the regular bench. Yes. This is for the day only. Tomorrow I don't have the determination. Sorry. Arising out of the order passed by this court. Yes. Hand over the slip. Of which year? Passed by which court?
One, my lord, Justice Calcutta, and another, my lord.
Very well. Hand over the slip. Yes.
Has matched the high price. However, this year the same authority has shown improvement with the over.
Hand over the slip. Sorry. Upgradation is not possible. Yes. Inclusion. Yes. Motion or hearing? Hand over the slip. Monthly list of January. Yes. Yes. Honorable Justice. Hand over the slip.
The
The
examination,
old contempt. Yes.
the examination is on 29th. By an interim order of this court, we were allowed to fill up our forms, but our application, admit cards have not come yet. The order was that it will abide by the result of the writ petition. Pleadings are complete. And this is item number 340 of your lordship.
Wait for some time. Sorry.
And otherwise, my
My
lord,
lord,
we will not.
No. I'm not including any hearing matter.
My lord, may I be permitted to mention a matter, my lord? My lord, this is in regards to challenging the seniority list published by the.
Here, motion or hearing?
It was lastly appearing as motion, my lord. Order was passed by the honorable judge, my lord, to complete the pleadings, but till then nothing has been.
Sorry.
No, my lord, I have prepared an application, my lord, the urgency is, my lord, the public.
Very well. Application under the heading application.
This is contempt application for violation of order of lordship's order dated June 2025.
Hand over the slip.
And this is another one. This is slated to be appear in the monthly list of November, but not listed. My lord, the order.
What is this?
Here. This is a service matter, my lord.
Service matter, hearing or motion?
This is hearing, but it
Wait, sorry.
just in the.
You have just heard. I am not allowing anybody. Yes.
This has already become out of list because of change of.
Yes.
Out of list because of.
Hearing or motion?
Motion, Lord.
Of which year?
2025 before puja vacation.
Hand over the slip.
File এখানে আছে হ্যালো ফাইলটা পাওয়া গেছে
Hand over the slip. Application.
ছিল না
Motion. Dismiss for when dismiss for default? This year 2025, 2013. So what you are doing for such a long time? Restoration application. Wait for some time, madam. Yes.
New motion. 2025, Group 6, inclusion in the for inclusion in the list.
You have mentioned once. Sorry, yes.
My lord, may I permitted to mention one matter for inclusion, my lord. This is motion stage, my lord.
Yes,
Service
yes.
matter 2025.
Motion, hearing or motion? What was the last order passed?
The last order, there was a direction to the other side to file a report in form of a affidavit.
When this direction was passed?
25th August 2025. 25th August, my lord.
So why you have not mentioned earlier?
My lord, it will be appear on 18th.
Mention in the after publication of the monthly list, not now. Yes.
This is motion, group 6, service matter. So this was mentioned earlier on, taken up on 19/4/2024. Post that it was mentioned by the Honorable Court that it taken up in the monthly list of June 2025. So promotion.
What was the last order passed?
We adjourned and listed in the combined list for June 2020.
At the motion stage or hearing?
Motion.
Motion
Motion stage, yes.
of 2025 motion.
2024. June 2024.
And the last order was passed when?
19th April 2024.
What was the order passed?
To be adjourned and combined with the monthly list of June 2024, Your Lordship.
Mentioned in the monthly list after publication of monthly list of December, not now. Yes.
May I mention for inclusion?
With the order. Bring the order. Yes.
May I mention for inclusion?
Inclusion for what? Hearing or motion?
Hearings.
Wait for some time. I'm not including any hearing matter. Yes.
Mention for inclusion. This is a long pending matter, my lord.
Yes.
This is a long pending matter. It was supposed to come in the monthly list of August, but it unfortunately didn't come. Under the heading for
Hearing or motion?
orders.
Wait for some time. Yes.
My lord, have you kindly to mention one new motion matter of the year 2025 for inclusion, my lord?
Hand over the slip,
and one
monthly list of
extension
December.
will
Wait. Yes.
Similar prayer, man. New motion 2025.
Hand over the slip, December. Call the list.
Grateful time.
Item number 1.
Your Lordship, I am for the Union of India.
Extension of interim order. When the interim order was passed?
Interim order passed, my lord, in earlier occasion, my lord, on
When the first interim order was passed? I'm not asking you to indicate the extension order.
first interim order passed, my lord, on 14th May 2025.
Supplementary আছে একটা। Right, left. Stand here. तुम खड़ी होगी कि जूनियर कौन है उनको क्यों फोन पॉकेट जी ये ऑर्डर इसको पकड़ो तो जब आपको की देना
Which post?
My lord, for the ECG technician.
Where?
My lord, that is all India recruitment policy. My lord, my client, my lord, Odisha.
Orissa.
All India recruitment. My lord, all India recruitment.
Where? Where Orissa in where he is to be appointed?
My lord, choice fillings given Odisha.
Yes, for which post? Where?
ECG technician.
Where?
My lord, where my lord, the all India, my lord, aims, my lord, conducting the recruitment for the post of ECG technician overall.
Very well. It is conducted by AIMS. But in which institute he is to be appointed?
That is ECS. That is authority, my lord, I am telling.
Lordship may take the supplement.
Wait. Where he is to be appointed?
Yes.
Show me the recruitment notification.
My lord, I. ESI authority. ESI authority.
How it is maintainable?
My lord, ESI authority, my lord, all India recruitment policy, my lord, ECG for the post of ECG. My client applied under the my lord, ESI authority.
So ESI authority appointment comes under the, does not come under the ambit of the tribunal. Yes, I'm asking you. You are who is appearing for the Union of India?
Your Lordship, in this case, I am appearing for Union of India.
Yes.
Your Lordship, kindly see order dated 6.
I am asking you, is there any notification under section 15(3)?
Your Lordship,
Under 14(3).
Your Lordship, this writ petition is already infructuous, Your Lordship, because
I am asking you whether ESI authority comes under the notification.
yes, Your Lordship,
Yes.
absolutely. But we have not got any instruction from the Union of India till date. But Your Lordship, I have submitted on 16th of June.
If I do not have determination, jurisdiction, I cannot pass any order.
The difficulty is that this case.
Obtain instruction come back whether the appointment in ESI comes under the purview of the Central Administrative Tribunal or not.
Yes, Your Lordship. Kindly necessary direction may be passed, Your
No
Lordship.
direction. Obtain instruction come back tomorrow. You are appearing for?
Respondent number 2. Yes.
Yes, sir.
ESI. What is your instruction?
Lordship,
Is there any notification so far ESI is concerned
my-
under section 14(3) of the Tribunal Administrative Tribunal Act?
I have not received anything.
Why not?
What I have received is
Perhaps in appointment in ESI does not come or does not come under the jurisdiction of this court after promulgation of Administrative Tribunal Act 1985. So you are appearing for ESI.
no
Obtain instruction, come back tomorrow.
My Lord,
Not today.
only one thing, Lordship. Here
Other things will come later because if this court has no jurisdiction,
determination.
court will
No-
not pass any order.
and
Your Lordship, kindly guide me whether respondent 1 will also bring the instruction. We are the Ministry
Both of you
Labor.
will, yes, both of you will obtain instruction.
Deeply obliged, Your Lordship. I will.
under 14(2).
Otherwise, you have to, for extension, you have to satisfy this court.
Absolutely.
You know everything.
And they have got
I
the
know.
relief also, Your Lordship. They have got the relief also.
How ESI authorities matter can be moved before this court?
My lord, the conducting, my lord, is
Maybe whoever may be conducting authority.
conducting authority aims.
Maybe. But where petitioner is going to be appointed?
My lord, after my lord selection, they are going to
Technician post in the state hospital. Who is the authority? Where you will approach?
and my lord, the aims authority, my lord, restrain me from filing the
Con-
choice.
examining body may be aims, but the consideration is where petitioner is to be appointed.
And my lord, rejection by the aims. Rejection by the aims. rejected my prayer, my lord, that is by the aims.
But the selection for which post?
Selection ECG
Now,
technician.
section 14, what is the part of section 14?
My lord, I am challenging here that rejection made by the aims authority. My lord, they are not, my lord, allow me to filling my choice through online and without any reason.
No, the reason was given in the supplementary affidavit. Yes,
This is the
kindly state the supplementary affidavit.
supplementary affidavit, my lord. After that, they intimated me.
Recruitment and matters concerning recruitment.
My lord, here rejection by the aims.
Yes,
not by the
but
inside.
this is for your recruitment.
My lord,
This is for your recruitment.
Yes, my lord, not rejected me. Yes, I nothing.
Understand?
No,
But this is relating to your recruitment process.
they are given for recruitment.
It says that the recruitment and matters concerning recruitment to all India service and any civil service of the union and civil post.
But here I am challenging, well, for that reason I file here. Here I am challenging the
How it can
rejection
be?
by the
How
aims
court is asking you? AIMS may have conducted examining body, but where is the if it is recruitment relating to an organization
Well, that
which
is-
comes under section
that
14(3)
is
of?
true, but here impugn, my lord, rejection by the aims. Here impugn.
So what? This is for recruitment. Matter relates to recruitment. AIMS is AIMS is an examining body for recruitment in a post in ESI hospital. So whether this will be heard by this court,
As the rejection made by the aims.
come back tomorrow. Obtain instruction.
Tomorrow, Wednesday, my lord, on Wednesday. Instead of tomorrow, Wednesday.
Achha, matter is record and order. Matter is heard in presence of the learned advocates representing the parties. Question arises for consideration whether writ petition at this stage is maintainable before this court in view of section 14 of the Administrative Tribunal Act 1985, as the matter pertains to recruitment in ESI hospital. In Odisha,
My lord, in all India, my lord, post choice fillings, my lord, my client willing to join Odisha.
where do you stay?
My lord, I am
Purbo Medinipur.
Kobe.
দাঁড়াও তো। All authorities are outside the jurisdiction of this court. New Delhi.
That's why that
All are outside the
that-
jurisdiction of this court. And you are to be appointed in an hospital in Odisha.
Well, that is choice filling. West Bengal has also, my lord.
and
there
if
was a-
lordship, if your lordship takes the supplementary affidavit, he is overaged. If lordship take the supplementary affidavit,
This
the-
was anything.
the
When I
mail dated 19th May. Kindly take
Well, obtain instruction whether ESI is an authority which comes under the notification under section 14(3). কি বলছিলাম? Recruitment in ESI hospital. ESI hospital, stop. Learned advocate representing the parties have prayed for accommodation. List the matter under the same heading for further consideration on Wednesday.
Wednesday.
On Wednesday next, 26th November 2025.
Deeply obliged.
Item number 2.
My lord, in this matter, Mr. Gautam Das is appearing on behalf of the petitioner. My lord, he is ill on behalf of his clerk. He requested me to pray for an adjournment. My lord, kindly make this matter not. আমি জানি না গো কি ইয়ে গ্রাউন্ডের কি বলবো
Matter was taken up on 3rd November. Court directed to serve notice. Where is the notice? You are appearing for the response. Not today.
Item number 3.
May I please, Your Lordship, I am for the petitioner. Here what happened, my lord, I appeared for the examination. My lord, last
Just a minute.
occasion.
Exception.
This is my exception. I have served to my lord. My lord, what happened in this case? I appeared for the examination for the year 2024 for recruitment of the constable GD in CAPA
2024.
2024 selection process. My lord, I qualified the first hurdle in computer-based examination. Thereafter, I appeared in PST and PET examination. I have passed. Then I placed before the medical examination board. In the detailed medical examination, I was my candidature has been rejected on threefold grounds. My lord, kindly come to page 26 of my writ application. This is the order passed by the detailed medical examination board assigning 3 grounds. Page 26, P5 of my writ application.
When the medical examination was conducted?
Medical examination conducted on, my lord, it was conducted on 8th October 2024. Button question.
Yeah, page 26.
26.
Yes.
This is the detailed medical examination board's finding. First ground was assigned knock knee distance, intermedicular distance, 5 centimeters. Carrying angle left.
What is the wrong in it?
Yes, I am coming. Left 21 degree.
You preferred review.
Yes, I preferred review.
Where is the order of the where
Order
is
of
the review report?
Review medical examination was page 27.
Page?
Page 27, next page.
Yes.
My lord, that is the my challenge. My lord, kindly have a look on the guideline. My lord, fee ground has been assigned by the medical board, detailed medical examination board, knock knee.
Where
carrying
under
angle.
which clause?
Yes, I am giving, my lord. Clause. Clause, my lord.
2015.
Yes. The guidelines for review medical examination.
Yes.
Clause. The review medical board shall examine the candidate specially for the deficiency of which for which the candidate has been declared unfit. Also in the medical term used as it was it is with that, it will be ensured that a medical board who has conduct DME of the candidate is not part of the RME board of the same candidate. The defect for which candidate has been declared unfit, supported by proper investigation report, if applicable. My lord, this is very important. And next, my lord, D also. Review medical board may obtain opinion from concerned specialist or super specialist of the government medical college and hospital in case of any doubt. Therefore, in case of rejection, review medical examination, clinical findings should be corroborated with conformity test, investigation, opinion of the specialist, super specialist of government hospital, medical college, government approved private medical center, whichever and wherever applicable. I am supporting, I am relying upon these 2 clauses of the review medical code.
Which is art.
My lord, here.
May.
Yes, may.
Review medical board may obtain opinion in the of the concerned specialist or super specialist or specialist of government medical college and hospital in case of any doubt.
In doubt.
It is not a case of any doubt.
Yes, doubt. There is a case of doubt.
Any doubt is expressed in the report or review
Yes,
report?
my lord, in the
Where?
yes,
Show me.
page 26. Page
Page
26,
26.
last ground, left testis enlarged. My lord, that is no ground for rejection as per this guideline. And findings of the review medical. My lord, kindly come to page 27 now. Hydrocele. This is the doubt. My lord, different two ground has been assigned by the two boards. In that event, the USG is mandatory. Threefold ground, third ground describes another one thing, and the final
No,
review
no. What
medical
about the
board
first ground? Knock
is
me.
first ground. My lord, it is up to 5 centimeter is acceptable, but
Where from you are getting this up to 5 centimeters?
my lord, kindly come to page in this medical guideline. I'm giving that portion. Knock knee, my lord.
Just a minute.
Page, sorry.
গাইডলাইনটা কোথায় পুরো মোটা গাইডলাইন আপনার কাছে আপনার কাছে রাখা ছিল আপনাকে দিয়েছিল
Comments. Yes.
Page 23 of this medical guideline. Well, at the bottom portion, the internal page has been marked. In top, some designation are there, but
Page
that is
26.
kindly ignore that. Well, at bottom portion, the internal page mark has been given 23. Page 23.
23.
Page 23, 2-3.
Yes.
Knock knee. My lord, two deformities, their assessment, knock knee. Malleoli of over 5 centimeter is a ground for rejection. And that only can be find by a X-ray report or obtaining opinion from the specialist on my lord, orthopedic surgeon. How to examine? There is a indication. And
just a minute, just a minute.
Yes.
আমাকে ভাই একটু গাইডলাইনটা দিবি হ্যাঁ আমি এক্ষুনি দিয়ে দেবো আমাকে দে আমার গাইডলাইনটা উনি কোথায় রেখে দিয়েছেন ভগবান উনি কোথায় রেখে দিয়েছেন ভগবান আমি তো দেবো দিয়ে দেবো
What does it mean? Knock knee 1 m distance on 5 centimeter. What is 1 m stands for?
Manually.
Or not manually distance in short form it has been.
What is manually?
Manually means the distance between two knees.
Well, suppose it has
Yes,
to be,
come to. Do you have this?
Yes, moreover, my lord, I'm showing another point, my lord, that will help.
Just a minute, one by one.
Judge sir খুঁজছে গুগল ছাব্বিশটা দেখাচ্ছিস 27টা
হ্যাঁ
হুম
Well, two things I must show you before your losses. Kindly come to
Come to page 26.
page 26.
Knock knee, then what is written? Knock knee, then
Knock knee, IM distance,
Distance.
IM.
IM.
Intermolecular.
Distance, then
Then the mark a sign
5 centimeter.
5 centimeters.
before 5.
The sign.
So sign.
I think
Medical
equal
term, my lord, I can.
thereafter equal to one part and subsequently thereafter the one the zigzag light should
Because, my lord, here
they have
we
a doubt whether it is equal.
Where from you are importing doubt?
Yes, that I
That I am asking you. When no doubt is expressed.
I must show, my lord, that then your losses come page 27. Clause 2. Kindly have a look. Brief review medical examination of finding.
Where,
So
where,
that
where? Page
Page
27.
27.
Page 27.
Clause 2. There is a doubt. Clause 2. Brief review medical examination finding. Intermolecular distance 7 centimeter. Here they have how they have come to that conclusion.
May I
that
submit?
It is a,
May I
আমি বুঝিয়ে দিচ্ছি দাদা তুমি পাবে তো ব্যাপারটা তুমি সিনিয়র দাদা my lord here they have a doubt some
Why?
board saying
Because
some board saying
the first authority says it is 5 centimeter.
yes 5 centimeter
Now the second review order says it is 7 centimeter.
centimeter.
So there is a doubt.
Yes.
Situation
That's why-
got worsened
that's why I am
by virtue of the order passed in review.
that's why I am drawing your kind attention to your losses my lord kindly come to first page there where I have indicated the guideline for review medical examination. Kindly come to there. Clause number 7. I am that for the knock-knee, what has to be done by the review medical examination that has been specifically mentioned and in that clause. But that has not been done. তুমি এসো দাদা দেখে নাও নইলে পরে মামলায় আবার আমাকে ধরবে তখন দেখে নাও বের করো ফিউচার জায়গাটা clause 7
But this page 27 intermalleolar distance is 7 centimeter. This is how this can be.
yes
Yes.
that is why I am asking your losses kindly come to clause 7 my lord the front page where your losses marked it for review guideline examination clause 7 I have shown your losses just now clause 6 then it's clause 7 your losses find it
In case of doubt. But I do not find any doubt
clause
expressed by
7
the.
my lord kindly come to clause 7
Yes.
clause 7 I clause I subclause I next page that will help your lawsuits to in knock-knee bole cubitus vegas cubitus valgus deformity x-ray plate is mandatory how this board comes to a conclusion that the knock-knee is more 7 centimeter that will help only after the x-ray examination has been done x-ray has been done otherwise the board cannot come to a conclusion that the Distance is 7 centimeter. My lord.
Yes, where is the extra
Yes,
plate?
yes. And another thing, kindly come to page, my lord. In that guideline, minor acceptance, page 8 of my internal page 8 of this guideline, minor acceptance clause, where the minor deformity can be accepted by the medical.
It's not a minor acceptance case. Yes, where is the extra plate? Please wait. Yes, where is the extra plate?
I have been look on that.
Yes, where is the extra plate?
Yes, Milord, if you lordship, now Milord, I am submitting. But before the review committee, Milord, page 27, my lord, the objection was raised initially in respect of 3 issues, that knock knee 1 m distance on 5 centimeter, carrying angle so and so, left testicular swelling so and so, enlargement. Now the review committee has examined. Now, my lord, a review committee, my lord, it has been examined by the review committee. Review committee has got its distance of 7 centimeter, number 1. Number 2, carrying angle measurement, RT 15 degree, LT 15 degree with permissible limit. Now they have indicated that within permissible limit. Now, my lord, gross left, my lord, thoracic, I believe nothing, but
Hydrosis.
I'm unfit on the account of knock knee, left proceed. My lord, these are the 2 grounds the review committee has found for rejection. My lord, it cannot be, my lord, we cannot deviate, even if 1 point, because my lord, they are the medical expert. My lord, we cannot determine what is the issue. My lord, he cannot deny it with respect of the, my lord, the enlargement of the testicles. My lord, he cannot deny it.
I am denying it. I have a document, I have an
Now,
with that.
please,
Now, in my lord,
that is apparent, the defects of medical, what are the findings of the medical authority? These are apparent from page 26 and 27. Now, he is taking a point
that whether X-ray was done or not.
In case of knock knee, it is stated in the guidelines, revised uniform guidelines dated 31st May 2021 under clause 7I.
My lord.
That for knock knee, clause 7I. Do you have the copy?
Yes, I have given.
No, I
My
have,
copy
but
I have given.
7I, that for knock knee, bole, cubitus valgus and varus deformities.
with the findings to be attached.
Where is the X-ray plate?
X-ray plate, my lord, with regard to that, my lord, I have to take instruction. I need 48 hours because, my lord, we have to.
Because it is your guideline.
My lord, I cannot deny
Government of India guideline.
Absolutely.
So
but whether
therefore,
there was an X-ray plate or not.
in your report, that the copy of the photocopy of the X-ray report should have been attached.
My lord,
in order to dispel doubt.
Whatever they have supplied, my lord, we have annexed. My lord, we cannot enlarge the scope.
Court has granted you leave to file an report. The report should be exhaustive in all respect.
Exactly, my lord. It would have been, must have been done. My lord, it was not there. My lord, I need only 48 hours, my lord, to take the appropriate X-ray. My lord, instruction whether the X-ray plate is there.
If you
then
cannot show the X-ray plate,
then my lord, matter goes.
That event, I will direct the independent medical body to medically examine the petitioner and furnish a report.
Well, I need 48
hours. Yes, not 48 hours. I will grant you 7 days time to file a further report,
my lord,
including X-ray plate.
Exactly, my lord, that is required. If I do not have, then I shall.
It should be on record.
Yes, my lord. I shall submit before your lordship.
No further. Sorry. Enough is enough.
Lordship says that this
No.
is not the minor defect.
Matter relates to appointment of GD in CAPFS. Matter relates to appointment of constable within bracket GD in Central Armed Police Forces within bracket CAPFS. Stop. Issue is whether on the ground of knock knee and hydrocele, petitioner should be debarred from getting appointment in the post of constable GD or not. While arguing the matter, Mr. Kundu, learned advocate representing the petitioner, in reference to 2 medical reports, one is dated 9th October 2024 and the review medical report, no, 9th October, no.
8 October.
8 October 2024 and the review medical report dated 9th October 2024 has submitted the deformity the deformity as knock knee, so far petitioner is concerned, is within the range of 5 centimeter.
Yes, 5 cent.
5 centimeter. Stop. It is also submitted based on a review medical report dated 9th October 2024 that though on medical examination it was reported that বানানটা না ভুল লিখেছে জানো, এখানটা করেছি intermalleoli distance or intermalleolar distance. Malleolar distance, M-A-L-L-E-O-L-A-R. 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 Intermalleolar distance is 7 centimeter. But that is disputed. And placing reliance on clause 7 within bracket I of the revised uniform guidelines for review medical examination in Central Armed Police Forces and Assam Rifles for G capital OS, GOS and NGOS. It is submitted that for knock-knee, in support of medical findings, X-ray plate needs to be attached. Stop. Next paragraph, Mr. Banerjee, learned advocate representing Union of India, has made submission based on a report filed on behalf of the respondent. But on perusal of report, it does not appear that X-ray in support of knock-knee as being the X-ray in support of knock-knee, which was found to be one of the reasons for declaring the petitioner medically unfit for being appointed as Constable GD in CAPFS. Sentence টা বলো তো।
ফোন করে তাড়াতাড়ি আনো।
হ্যাঁ স্যার, ফোন করে দিচ্ছি, গাইডলাইন কপি ডেট চাইনি স্যার।
আনান
কি ফোন করে দিচ্ছি, ডেটটা কবে পড়ে দেখি ডেটটা কি হয়, comma is not enclosed to the report. Learned advocate representing Union of India has prayed for accommodation to produce X-ray report or to take instruction in this regard. Next paragraph. Further leave is granted to the respondent authorities to file a supplementary report disclosing X-ray report based on which medical experts opined that petitioner had knock-knee. Let such report, additional report be filed by 10 days from date. Stop. List the matter under the same heading for further consideration on. December 2025.
Malad 11 December, Malad 13, the last year 13 December, the panel was published. In the by this time, 1 year will be.
Maybe, but you have filed the writ petition within a year.
That even, Malad, may I pray for interim order?
No, nothing at this stage. You have filed the writ petition already within the panel, within the lifetime of the panel.
Yes. Another thing, Malad, apart from this year, same ground has been assigned and passed that petitioner.
Passed the?
Petitioner passed that medical exam.
He has been declared fit.
Declared fit on the knock. This is a permanent disability.
না, ওটা এখন রাখো, সই হবার পরে দিয়ে দেবে। Next.
Item number 4. For item number 4, I beg to appear for the respondents, my lord, virtually. Lordship will kindly allow me to address my lord online.
Lordship, I'm appearing for the petitioner. Lordship, I'm led by my senior Mr. Shomo Mujumdar. Lordship, pursuant to Lordship's last order, I'm filing my affidavit of service.
Yes.
Lordship, here the petitioner was an employee of UCO Bank, Lordship. Lordship, in 2016, he was posted as a lead district manager in Howrah. Lordship, while he was posted in Howrah, he used to receive officiating allowance for discharging higher nature of duties. Then suddenly, all of a sudden, when a scale 4 officer was again appointed in that particular post, that officiating allowance stopped. Then again, it was restored when that scale 4 officer got retired. My lord, kindly see page number 19. There we have indicated that in which period he has received the officiating allowance and when he has not received the officiating. Kindly see page number 19.
So intermittently officiating allowance was withdrawn. This is your grievance.
Lordship, the grievance is that all of a sudden the officiating allowance was recovered. They have
Recovered.
The bank has recovered from
your salary.
From the salary, my lord.
After paying officiating allowance, it was when it was recovered.
Lordship, the recovery process started from.
This is 68,388 total.
Total.
That is recovered.
That is recovered.
Now you are objecting this recovery.
This recovery.
And this calculation is at page 90.
90.
Now you are praying for refund of this officiating allowance.
And also my arrear, my lord. The arrear, Lordship, I'm stating.
Now show me your entitlement to get officiating allowance.
Lordship.
That you are entitled to get officiating allowance, considering the post held by the petitioner. That is the crux of the issue.
Lordship, kindly see page number 18, my lord.
If it is wrongly paid, then the authority employer has every right to correct it.
Lordship.
So that's why you have to demonstrate before this court that considering the post held by the petitioner is entitled to get officiating allowance.
But Lordship, similar circumstance employees in different districts, they used to receive officiating.
That is not there is no concept of negative equality.
Lordship.
One may be wrongly paid.
Lordship.
That does not confer right upon the petitioner to pray for the same relief, same benefit if he is not entitled. So therefore, show your entitlement.
Entitled.
That you are entitled to get officiating allowance. So, XYZ are getting, that does not confer right upon the petitioner to demand or claim, because today you are before the court seeking a mandamus. Now, therefore, you have to assert your right by relying upon a relevant clause or provisions which confers right upon the petitioner to get this officiating allowance. Demonstrate this.
Lordship, can I come back with instruction?
The case of allowance and you are appearing junior member of the bar and you should come with fully ready that yes, this is the provision which accrues right in favor of the or which grants right to the petitioner to claim this benefit. Where is such provision?
Let me come back with certain instruction. I'm led by my senior Mr. Shomu Mujumdar in this matter.
Yes.
I'm led by my senior Mr. Shomu Mujumdar in this matter, my lord.
My lord, may I just take 30 seconds, my lord?
Yes.
My lord, he's right that there was an amount of, my lord, officiating allowance that was paid to the petitioner. But as rightly pointed out by my lord, that was wrongly paid because there is a circular of UCO Bank, which is the principal respondent, my client, of 1999, according to which the petitioner for the position that he was holding up until his retirement was not entitled to that. So, my lord, with respect to that part, may I be permitted to bring that on record by way of an affidavit in opposition? There are
No,
certain
not at this
internal.
stage. At the motion stage, let the opportunity be given
Very
to
well.
the petitioner to substantiate his claim.
Very well. I'm grateful.
That this is his right to get the benefit.
I bow down.
Now, since you are representing the bank authority,
No,
is
I
there
know.
any provision which grants right to the petitioner to or to the employees who are similarly situated like petitioners
No.
get officiating
No.
allowance?
In fact, on the contrary, there is a notification that they will not be entitled to officiating allowance.
Where is that?
Well, that is, my lord, page number. They have annexed it. We are relying on certain other communication also, but the one that they have annexed is page number 21 onwards of the writ petition.
Which part says that relating to grant of officiating allowance?
My lord.
Officiating at branches. Yes.
My lord will kindly take up 21A, which is
Yes.
the typed copy.
Yes, yes.
My lord, he doesn't come within the ambit of any of this.
This
A, my lord,
workman
is
staff.
yeah, he doesn't come under that, my lord. Or any of them, my lord. 22A, if your lordship also takes up. But I have taken instruction from the bank, my lord. There is no, they've gone by the service records of the petitioner.
Lordship, kindly see page number 22 then.
My lord will also take up 39.
Just a minute.
I'm sorry.
You are coming under which category? In 21A, 22A? This is the guideline relating to grant of officiating allowance, dated 24th April 1999.
Kindly see page number 22, my lord. There is a general
22.
condition. Page number
Ye-
22.
Yes.
That officiating allowance will be payable only.
Page number 22, yes, which clause?
Kindly see general conditions, my lord. Officiating allowance will be payable only for actual performance of higher responsibilities as per settlement service regulation. Lordship, the petitioner was actually performing higher responsibilities, my lord. The post of LDM was given as for ad hoc basis, my lord.
Officiating allowances will be payable. There is a general conditions, but that is covered. That is to be considered based on paragraph A. That is page 21A.
Now let me come with some instruction.
Yes.
Grants me 1 day's time. I will come back with instruction.
Not today.
Well, there were certain internal communications of the bank, my lord, with respect to this specific point. What would, for the case of administrative officers or head offices, officiating will not be allowed. These, my lord, if my lord kindly allows, my lord, I'll be able to do proper.
Yeah,
my lord,
let him substantiate his preliminary case first. Then, if it is necessary, I will direct you to obtain instructions.
I'll only file a short,
When
very
this-
short affidavit. my lord.
When this refund was made, when this recovery, it was recovered, August 2018, last.
December 2018 to March 2019.
Yes.
December to March.
March.
20?
2018 to March 2019.
When this recovery was made from your salary.
From December. Kindly see page number 27, my lord. From there, the deduction started.
Yes, that is.
Kindly see
Where is the date?
From there, the deduction started.
29 December 2018.
Yes, 2018, the deduction.
When the last deduction was made, it was phase by phase, it was deducted. In installments, it was deducted. So when the last deduction was made, for in which March
2019.
So why you are coming after such a long time?
So that is another point we would have taken, my lord.
Lordship, we have made several representations.
After 6 years, why you are coming?
We have made several representations, my lord. The last representation.
Making representation cannot save the time of limitation. Though there is no statutory period of limitation in filing the writ petition, but Supreme Court has said it has to be within a period of 3 years. So there is no scope for passing any interim order.
And plus, my lord, he has superannuated.
I was under the impression that this is a current issue, not that
No, Lordship, the petitioner is retired, my lord. Retired from service.
issue.
Lordship continued service thereafter till 2020.
Matter is heard for exchange your affidavits.
My lord.
Matter is heard in presence of the affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Matter is heard in presence of the learned advocates representing the petitioner and bank authority. Next paragraph. Grievance of the petitioner is recovery of officiating allowance from petitioner's salary in installments. After such allowance was allowed to the petitioner till August 2018. Stop. However, on hearing the learned advocates, it appears that this process of recovery was complete in March 2019. In March 2019, and petitioner has approached this court with the present writ petition, which was filed on 13th February 2025, after 6 years. Precisely after 6 years. Stop. Issue needs to be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by the petitioner after be filed by the petitioner by 2 weeks after ensuing Christmas vacation. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
I mean, extremely
Item number 5.
Matter is heard in presence of the learned advocates representing the parties. Representing the parties. Now, petitioner and bank authorities. Learned advocate representing the bank authority appears on virtual mode. Yes, next matter.
Item number 5.
Your Lordship, in this matter, I am appearing on behalf of all the respondents, including shipping,
Yes.
as it was disputed in the previous hearing, Your Lordship, that who will be appearing on behalf of shipping. And I have bought the instructions also from the shipping. Yes, Your Lordship.
Yes.
Yes, regarding the compensation account, my father was died on the year 13th April 2020.
Who died?
My father.
13th?
Petition number 2. My lord, mother and
When father died?
my lord died on 30th April 2020.
30th April
2020.
2020. Yes.
2020. A representation made for compensation appointment on 4th May 2020.
Yes.
My lord, thereafter, my lord, during pendency of this writ petition, my lord, they called over phone, they called, the authority was called and directed to file the forma in the month of March. The writ petition was filed in the year February
2025. Yes.
February 2025. This is the position where my father was died on duty.
So you were asked to submit pro forma in the March 2025.
25.
Now till date, no response.
No response as yet.
Your Lordship, I have got the instruction, and as per my instruction is concerned, when the petitioner died, his working hour was
No,
from
petitioner did not, petitioner's father died.
father died, my lord. His working hours was from 6 to 12, 6 to 2 o'clock in the afternoon, but he left his working hour at about 1:30 p.m., your lordship. And after leaving his job, he passed away. And after he went home, then happened, your lordship, then he was taken to the medical, but he was not on duty at that time. And I have the written instruction with me, your lordship. My lord, kindly this be taken on record, your lordship. If my lord may ask, I can give it in affidavit also.
So if the employee is not, if the employee does not die during the working hours, he is not eligible to be appointed on compassionate ground.
Lordship, this is the instruction they have given.
No,
to
I'm
me. Ask
asking
your
you, what
lordship.
is the provision?
Lordship, I have to take instructions on that.
Again instruction.
On that, your lordship.
If employee
because-
does not die during the working, suppose an employee's working hours is from, as you have submitted, from 6 a.m. to 2 p.m.
Yes, your lordship.
in the afternoon.
Yes, your lordship.
And the employee dies at 8 p.m. at night.
Yes, your lordship.
Then if it is a genuine case, then the dependent family member will not be favored with an appointment on compassionate ground.
Absolutely, your lordship. Then we have
What
to.
does the scheme says, for which no instruction is required? You are an advocate of this court. The scheme will guide you.
Yes, your lordship. I have to discuss
Where is
this.
the scheme relating to appointment on compassionate ground?
Yes, your lordship.
Instead of going into this factual aspect, whether the father of the petitioner number 2 died at 2 p.m. or 1:30 p.m. in the afternoon, you need to rely upon the scheme.
Scheme, yes, your lordship.
If scheme confers right upon the petitioner to be appointed if it is an appropriate case,
Absolutely.
then the timing or time of death is immaterial.
Yes, your lordship. I will sit with the department so that in the scheme, if there are the possibilities, we will.
Where is the scheme, madam?
I don't have the scheme
Why
with
not?
me right now.
This matter was heard far back on 4th November 2025. Today we are on 24th November 2025.
Yes, your lordship.
You are an advocate of this court and you do not know the provision relating to appointment on compassionate ground. So far the engagement of the father of the petitioner is concerned.
Yes, your lordship. I understand.
Then I have to direct the department to appear before this court personally.
Lordship, I will
If
get.
these instructions are being obtained in a piecemeal manner, what is happening?
I apologize.
Yes.
On behalf of the department, I apologize. I have asked for the scheme if there are any possibilities. They said they will revert us back to very soon, your lordship. Just give me some time in that case.
To say so,
So
when you
detail
are
the scheme.
handing up this document, it's nothing but a parawise instruction.
This is the report they have
Don't be
given.
too clever before this court, madam.
No, not like that.
You could have submitted at the threshold that I am not with the appropriate instruction. Grant me some time.
Yes, sir. I have already said them. I have made
What is
several
this?
calls also,
You are
email
a
also.
junior member of this bar.
Yes, your
You
lordship.
should be candid before this court, submitting that I need further time to obtain instruction. I could have considered your prayer.
I understand you. It's my fault.
So why you have not obtained instruction for such a long time, for
Lordship,
20
I
days?
have already called them several times. Give me the scheme and what are the details, provisions are there.
So they are not responding.
They have.
Court knows how to ensure this.
Your lordship, last week.
If you say that you are not getting appropriate instruction, then let me direct the Shama Prasad Mukherjee port is the
Yes, your
authority.
lordship. Yes, your lordship.
So you are
We are-
representing port.
Now we are representing myself and Mrs. Priyanka Tibrewal. There is no other representative council.
The chairman of the port remain present before this court tomorrow at 10:30.
Yes, as lordship deems fit, or give me one more chance. I will send
At the
the mail
impaneled
once.
advocate of port.
No, your lordship, that was the.
Then how you can appear on behalf of port?
Lordship, from Union of India, I have been myself and Mrs.
No, that is not the
Tibrewal.
system. Port has their own
Yes, your
own
lordship.
paneled advocates.
Yes,
Have
your
you served upon the port authority?
They have served. They have already.
Why you are taking the burden? Representing for the Union of India. Union of India advocate does not appear for the port.
I understand. It is absolutely correct. This was the
You as an
confusion.
employee of Kolkata Port Trust.
Yes, your lordship.
So say so.
From
Why
Union
you are
of India, it
representing
has
for the
been.
all port trust have port trust is their own legal department and own panel.
I know, sir, your lordship, but from
Mr.
Union of
Ashok Jena generally
Yes, your
appears on
lordship.
behalf of port trust.
Absolutely. That also I have discussed with them. But as per the instruction of Union of India, myself and Mrs. Tibrewal will be representing
No,
all the
that is not the
respondents.
system so far the port authority is concerned. When you have served upon the port.
My lord, on sixth,
Sixth,
this, my lord, order dated
November,
on 4th, 11/2025. My lord, 6/11/2025, I have served.
Serve upon Mr. Jena.
Yes.
Take it back.
Repetition.
Serve a notice. Serve a notice. Affidavit of service filed on behalf of the petitioner is taken on record. In spite of service upon Hamaprasad Mukherjee port authorities being respondent number 224, those respondents are not represented. Stop. Learned advocate representing the learned advocate representing the petitioner is directed to serve notice upon Mr. Ashok Kumar Jena, Jena, Ashok Kumar Jena, learned advocate, who usually represents Shama Prasad Mukherjee Port by November 2025.
Instead of 27, my lord, I have some.
No, you have to serve.
Yes.
You serve by 27. I am not fixing on 27. By 27 November 2025, list the matter under the same heading for further consideration on 9th December 2025.
My lord, my appearance may be recorded, your lordship.
Yes?
My appearance may be recorded.
Yes, you give your appearance.
Deeply obliged.
Item number 6.
I am appearing for the Union of India.
I, my lord, the petitioner appeared in the examination selection of constable and he became successful. In the written test, he became successful. Thereafter, my lord, he was called for
When he participated in the written examination.
the written test participate.
When it was held.
My lord, it was held on examination written paragraph 9(2) I have stated. A letter dated December 2024. Thereafter, my lord, examination in 24, he became successful. Then he called in the medical examination. The problem started from the medical examination stage. Kindly look at page 19. I was declared fit. Page 19.
My lord, it's declared unfit, not
Yes,
fit.
yes. Subsequently, my lord, I declared
No. Page 19 is the unfit.
medically fit for the said post.
Unfit.
After due examination, I declare him medically fit.
Unfit.
Who unfit? Medically fit.
Come to page 23, unfit.
Yes, 19
I will
fit.
kindly see 19, what he's pointing out, my lord.
Page 23, 19.
Page number 19, my lord.
19,
which he's pointing
certified that Mr. Vikram Datto, son of Bola such and such, examination where
the second
photo
paragraph.
and thumb impression are prepared duly at such and such. I, the undersigned, have knowledge
Medically unfit.
That's what I'm pointing out, my lord.
No, in my opinion, this is an error judgment due to following reasons. After due examination, I declare.
I, the undersigned, have the knowledge that Sri Bikram so has been declared medically unfit.
By the medical officer for the post of constable such and such due to deranged.
So why you are saying fit?
Next line. In my opinion, this is an error of judgment due to following reasons. After due examination, I declare him medically fit for the said post. So,
but subsequently there is an
subsequently, my lord, then my lord, page 20, again I was declared qualified. Qualified. My lord, result of PSP strikeout is not applicable, then qualified. Then, my lord,
This was done by Naresh Kumar, Center for BSF, such and such, their authority. Now, my lord,
Deformity is deranged carrying angle.
yes, their authority, my lord.
What is this?
My lord, it's a gun stock deformity, sort of a deformity in your carrying angle. My lord, if that is there, he cannot be appointed for a post of a constable because it's a gun stock deformity. Now, subject to correction by your lordship, my lord, it's there in the guidelines. I can explain. I can peruse it, show it to your lordship. My lord, there was a detailed medical examination.
For 3 grounds, I was sent for re-examination.
No, my lord.
ENT successful, 2 successful, X-ray carrying angle. This carrying angle has created problem. They are saying normal.
It relates to your elbow.
My lord.
Yes.
Yes, my lord.
এটা তো ঠিক আছে normal 10 to 15.
Yeah.
দেখি দাও তো।
Eleven 20.
Yes.
So, my lord,
So he was found that there is a deformity which is called deranged carrying angle.
Yes.
So how you can get rid of this?
My lord, our contention is that this is afterthought because when earlier exam, their doctors examined me. They declared me unfit.
Earlier?
Earlier, their department.
Yes.
They declared me fit. Subsequently, there one gentleman saying I am unfit. From private
At
doctors.
which stage this declaration was made as you are submitting, Mr. Mustafa? Page 19.
Page 20. Page 19, my lord, after becoming successful in the, my lord, written test, I was sent for medical test.
Yes.
In medical test, I was declared medically fit.
Then
my lord,
when it was detected that you are
then, my lord,
suffering
again
from
we were-
carrying angle,
they for 3 counts, I was again sent for board, before the board. There, my lord, this carrying angle was discovered.
now you could have preferred a review against this.
He did, my lord. It was reviewed. It was declared unfit. Now there is no provision to appeal against the review medical examination.
Where is the review order?
Review order was not with us.
Why not?
My lord, he has annexed this. My lord, page 23 is the review order. Review medical examination.
Where is the first order?
My lord, the first order is the one on page number 19.
But that is who preferred review? Because it was
He
medically
himself-
fit.
My lord, he was declared unfit.
I was
So
preferred.
after due examination, I declared him medically fit.
My lord, but it was declared medically unfit. If you see the second paragraph, my lord. This was
A second
what I have been
paragraph,
told.
then the
Medically unfit.
then after due examination, I declare him medically fit
For the
for
said
the said post.
My
Come to please read this particular portion
My lord, I've
of
read it.
page 19.
My
First, in my opinion, this is an error of judgment due to following reasons. Carrying angle, after due examination, I declared him medically fit for the said post.
My lord,
So
subsequent.
if petitioner was declared medically fit,
My
where is the question of preferring review?
My lord, it was reviewed because, my lord, I have written instructions.
Why it was reviewed? But review has to be at the instance of the candidate.
No, my lord, it was
This,
done. in
but the
this
candidate
instance.
did not suffer any preliminary medical report,
My lord,
adverse medical report.
But my instruction is that in this report itself, he was declared medically unfit.
How? Demonstrate this.
Well, let them file affidavits.
No, no.
Wait.
No. No. My lord will kindly have this, perhaps it will
No,
be
no.
clear.
Please explain it.
After due examination, I declare him or her medically fit for the said post.
So there is no question that the petitioner was aggrieved by this preliminary medical report, which is at page 19.
One
I
moment.
accept. I accepted.
My lord, just give me a
Yes,
second.
that was in your favor. So who preferred review?
After being declared medically unfit by the DME Recruitment Board in Murshidabad, the review medical examination was conducted.
Where is the medically unfit? Page 19.
My lord, I have another copy as well. One second. My lord, this is the report of.
Very well, find it out.
No, my lord, I have a report of the detailed medical examination.
Find it out.
My lord will produce this once.
Come back, you go through the papers and then explain it.
Very well. been able to manage and find out the confusion with regard to this document.
My lord, I have been instructed to be candid. This was, my lord, on reference. He treated in a private hospital. The form is of the department, but report of the private doctor.
It's not done by the nodal agency.
So, my lord, then, my lord, kindly look at page, next page. They referred me to the Gauri Devi hospital.
Just a minute.
Department of Orthopedics, my lord, in Murshidabad Medical College and Hospital.
Then C is correct. Then the first report.
Yes, C is correct. Then, my lord, I was referred, they referred us to page 22, Gauri Devi Hospital. Carrying angle left, 15 point. Carrying a right, 11 point. No obvious bony fracture is seen. Joint space appears normal. No obvious soft tissue normal is seen. Carrying angle left 15. So this is final. Now, my lord, they are.
It is also private hospital.
Yeah, no, it was.
My lord, this is a private hospital, but as per the instruction of the officer, they are referred there if there is some confusion. And then this.
This hospital was authorized to.
Yes, my lord. And after
perform these tests.
My lord. So after when this test is performed, then there is a review medical examination which was done of this petitioner.
So then the entire color of the issue gets changed because in the first report also, yes, joint space appears normal, then no obvious bony fracture, but no obvious tissue, then carrying angle left, then carrying angle right. And then since you are declared not medically fit, but there is no specific observation whether the petitioner was found medically fit or unfit.
My lord, in the review medical.
22, page 22.
My lord, they have only written the carrying angles. This was taken for the review, where my lord subsequently.
No, there must have been, as it is done nowadays, every matters are coming.
My lord.
Then it is specifically an opinion, it is opined by the medical expert.
My lord.
While preparing the first medical report, whether petitioner is found to be fit or unfit. Where is such endorsement?
My lord, the instruction is that only these measurements were taken before Gauri Devi.
Then where is the wrong in it?
Wrong is, my lord, if carrying angle left, my lord, 15 point, right, 10, 11 point. If that is the standard that I am, my lord, according to the standard, I am fit. And now here they have, my lord, said.
But it is already found 15 degree and 11 degree.
So this is in the category.
This is in the category of fit. Show me. Under the guidelines that he should be, petitioner should have been adjudged as a fit candidate.
It is in their guideline, my lord.
My lord, as per the guideline, he is declared unfit. And
no, that is standard. 15 and 11. 15 and 11.
Deranged carrying angle, it says.
Carrying angle. And even
any guideline regarding carrying angle? What should be the parameters for declaring a candidate to be unfit?
My lord, if my lord will kindly have page 7 of this that I haven't handed over, my lord.
Yes.
General grounds for rejection.
We are only on carrying angle.
One second.
Page 7. Yes,
page 7. Now, my lord, these are general grounds for rejection.
Yes.
If my lord will come on the subsequent page.
Yes.
26, cubitus varus. So if there is this deformity, this is a general ground for rejection. Which, my lord, he is found to have.
Now, subsequently, in some of cases, it is found that what should be the parameters? It is a general
And my lord,
general ground for rejection.
My lord, and if it's a minor acceptable defect, then there is a different category. If my lord will see at the subsequently minor acceptable defects. So my lord, he is clearly falling under general grounds for rejection.
Come, just a minute. Yes, just a minute. Come to clause 7A.
My lord.
Candidates with carrying angle up to 20 degree may be accepted if the same is not associated with abnormality of
elbow joint. So my lord, I do not know if there was
there is such consideration by
elbow. If my lord will kindly have this detailed medical report.
Candidates with carrying angle up to 20 point may be accepted if the same is not associated. I am at 15. Okay. Delete. It is.
Yes, show me. I am not a medical
Second
expert.
page, my lord, it's
Show
in
me.
unfit. My lord, pardon me. My lord.
Yes,
My lord, it's been circled.
up to 20 degree is permissible limit.
My lord, there,
Up to 20 degree is permissible limit, and the review order discloses that 5 degree and 6 degree, right and left.
my lord, then my lord, let the officer come. My lord, let him explain. My lord, gives me a day. He is not been able to attend court today. I'll
5
bring him
degree and 6 degree X-ray carrying angle, 5 degree and 6 degree, where your guideline clause 7M says candidate with carrying angle up to 20 degree may be accepted if the same is not associated with abnormality of
So my lord,
elbow joint.
to find out
No
if
abnormality of elbow
elbow
joint is
joint.
demonstrated in the medical report.
My lord. My lord, then let me find out, my lord,
File a report.
if with regard to his elbow joint. My lord, I'll file a report. Very well.
My lord, people earlier, my lord, Mr.
Any earlier report, there was a direction to file report.
My lord, Roy was taking up. Then there was a direction to file the report.
No, my lord, I was not there that time. I cannot say.
Everyone.
Matter is heard in presence of the learned advocates representing the petitioner and Union of India. Stop. Petitioner participated in the selection process for being appointed as Constable GD in Central Armed Police Forces within bracket CAPFS, but the petitioner was found unfit as it was found that petitioner had
Deranged carrying angle.
carrying angle,
Deranged carrying angle, my lord.
carrying angle করো শুধু carrying angle করবে carrying angle comma right hand 5 degree and left hand 6 degree as it appears from the review report dated 21st October 2024, which is at page 23 of the writ petition. Stop. Next paragraph. On perusal of the guidelines for next paragraph, on perusal for recruitment, on perusal of guidelines for recruitment medical examination in Central Armed Police Forces and Assam Rifles as revised on May 2015. It appears that under clause 7 within bracket small m, it is provided that candidates with carrying angle up to 20 degree, একদম 20 degree করে দেবে, may be accepted if the same is not associated with abnormality of elbow joint. Stop. Next paragraph. On perusal of medical report, it does not reflect abnormality of elbow joint. Therefore, prima facie it appears, since it is found in review medical report that petitioner has carrying angle which is restricted to 5 degree in respect of right hand and 6 degree in respect of left hand, semicolon, question arises why petitioner was not adjudged as medically fit candidate. Next paragraph, learned advocate representing Union of India has prayed for accommodation. Stop. Concerned respondent authority is directed to file a detailed report as to why petitioner was adjudged as medically unfit by 10 days from date.
My lord.
Detailed report in the form of affidavit. In the form of affidavit by 10 days from date. List the matter under the same heading for further consideration by 10 days from date, and a copy to be served upon the learned advocate representing the petitioner. Stop. list the matter under the same heading for further consideration on
11th December.
8 December 2020.
My lord.
Other matters you have fixed on 11.
It will be as per my convenience.
Yes.
Not for other matters.
My lord, kindly accepting it on any.
Say so.
Yes. Accepting it on any.
9 December.
Yes. I'm accepting. No others matter. I was here.
Next matter.
Grateful, lordship.
I am grateful.
Item number 7.
Number 7, I have been instructed to appear on behalf of Coal India Limited and also the Bharat Coal Limited. On behalf of Coal India Limited, my mandatory is council leader.
Who is appearing for Bharat Coking Coal Limited? And Coal India Limited?
Mr. S.M. Obaidullah.
And Bharat Coking Coal, have you served?
Yes, Bharat Coking Coal has been appearing from the beginning.
Last occasion matter.
There was a direction to serve on Coal India. I have served and filed the affidavit.
We have raised the jurisdiction point. Then the management point out that he.
No, who appears on behalf of Bharat Coking Coal?
I myself.
And Coal India?
Both. My counsel on behalf of Coal India Limited, my land place happened.
Yes. Yes, what is the matter about?
May I?
It's a point of jurisdiction you have taken.
I have taken on behalf of the Bharat Coal.
On what ground?
Because we know petitioner resident in Jharkhand, authority, concerned discipline authority, Jharkhand, appeal authority, Jharkhand, and note sheet as per proposal, note sheet, that has been prepared in Jharkhand.
Yes.
Is non-maintainable. But last occasion, my learned friend submitted before Lord Sri, he asking for promotion, not that he challenged the inquiry proceedings. So promotion will be granted by the Coal India Limited. His jurisdiction is Calcutta. So this court is jurisdiction. That's why minor directed to the petitioner to serve notice to the Coal India Limited and matter.
Yes, if it is a case of promotion, then why this court does not have jurisdiction? If the promotion is guided by,
I have taken instruction from Coal India Limited.
if the promotion matter relates to promotion, then why petitioner's case will not be considered by this court?
If the promotion is a case, then Coal India already considered this promotion and cancelled due to non-clearance of vigilance and etc. That has been.
That is another thing. That is on merit. Court is prima facie, or at the very beginning, court is considering whether the court is having territorial jurisdiction or not. So to that extent, what is your submission? If it is a case of promotion, then whether this because promotion is handled by the Coal India.
Coal India Executive Committee.
So their office is in Kolkata.
Yes.
So this matter does not relate to your discipline.
But I am not challenging my disciplinary the penalty order. Well, I am claiming promotion on the basis that the penalty order has been clarified on a later date to say that it does not have any period. Firstly, my lord, the penalty order was passed, that is at page 18, which says, my lord, stoppage of increment without cumulative effect for 1 year. Thereafter, it has been clarified, and during this 1 year, the promotion exercise took place. So I was not considered, stating that that 1 year period is going on, your penalty period is going on, so you will not be considered. That is what we have been said verbally. But thereafter, my lord, this has been clarified, and to the extent that this order does not have any fixed period. So this stoppage of increment will remain with me until I retire. So there cannot be a fixed period for which I cannot be considered for promotion. Otherwise, this will become a second penalty for the same misconduct.
So rest of your career tenure, you will not get promotion.
No, I am not challenging that. I have preferred and statutory appeal. No, I will not get increment. Stoppage of increment. Promotion.
No, the effect is that you will not get promotion for the rest of your tenure.
That the penalty does not say so. That is my case.
But it appears so that the respondent authority, since your effect of your punishment is continuing, so you will not be considered as fit to be promoted.
The effect was earlier, initially, the effect was for 1 year since it mentioned 1 year. So I was kept out of consideration. Now that 1 year has been clarified to be, that's improper. That 1 year should not be there in the order. The clarification note says. Therefore, my lord, there is no particular period. This will
No, there is a particular.
Allow him, I will hear you.
This stoppage of increment, it's for the punishment is stoppage of increment and not for any particular period. So stoppage of increment will continue till my retirement.
Therefore, the result is this, though it is not there in the punishment order, that you will not get promotion till your retirement.
That cannot be, because the penalty does.
That I
Yes,
understand,
yes,
but
yes.
this is your grievance.
That
since the effect of this punishment order will continue till your retirement, you will not.
cannot be department promotion. I have to.
No.
That is not your instruction.
That's absolutely. His punishment period already over. 2022, 31st July. Over.
So now there is no difficulty in.
No difficulty. Next time he will enter it.
Yes.
Kindly see.
That is communicated by the BDCL.
Kindly.
Just a minute. Pursuant to the TPC held on.
My
Just a minute. Just a minute.
Oh, ये था अच्छा अच्छा
So it was cancelled in 8 June 2022. And it is stated that head of the department survey BCCL communicated via this mail dated 1st of February 2022. VDA has informed that a penalty has been imposed to the petitioner with stoppage of 1 annual increment with cumulative for 1 year with effect from 1st August 2021. Video order number so-and-so, order reference number so-and-so dated 28 September 2021. Now, the penalty imposed to Sri Mukherjee is under the currency period. As such, his candidature for the post of officer survey E1 grade is hereby cancelled.
Therefore, they are again basing their ground for not considering me is that 1 year period. Now, Mara kindly comes to page 22.
Page 20
and 22 of the writ petition. Clarification note. Mara kindly considers note 11.
Just a minute. Yes, from there. Stop it. As per the certified standards. It is wrongly stated without cumulative effect for 1 year. It should be with cumulative effect for 1 year.
Can you have a look at the standing?
It is clarified here that with stoppage of 1 annual increment with cumulative effect for 1 year. not without.
Kindly have a look. Kindly have a look at the standing order. What the penalty is prescribed.
Where is your original
If he eligible
order
the
of
standing
punishment?
order, then he should have to go to the Jharkhand High Court. Because that is about
Where, where is your
Page 18.
page?
18.
Page
18, 1 8.
Yes, stoppage of increment without cumulative effect for 1 year with effect from 1st of August 2021. It was clarified that without cumulative effect for 1 year, hence it is stated that from the above note 10, it is clear the stoppage of increment cannot be reinstalled as per the provisions of certified standing orders applicable in the, as such the order of punishment dated 28 September 2021 is defective to the extent of without cumulative effect for 1 year. With cumulative effect for 1 year it should be.
Punishment order is-
Without cumulative effect for 1 year.
Yes, the total phrase it has
It,
been
it
quoted.
does not make any sense.
That doesn't mean say that there has no punishment.
No.
Punishment is there.
This without made the difficulty. Without cumulative effect for 1 year. Hence, the proposal is returned for further necessary action at the area level.
That also coming in 2024. Already promotion period over.
Lordship, kindly have a look at the standing order once, my lord. This is what the punishment
No,
is.
no, it cannot be.
Then he has to
Please allow this court. What is happening? Please take your seat. Court is also trying to assess the matter. Please take your seat. Don't interrupt this court. Court will ask you and hear you. Now come to the punishment order.
Right.
28 September 2021. Stoppage of increment without cumulative effect for 1 year with effect from 1st of August 20. It does not make any sense if it is without. It has to be with cumulative effect.
But it's because it's
Then it is no punishment at all.
no. If it's without cumulative effect means, my lord,
Stoppage of increment without cumulative effect. Without cumulative effect for 1 year with effect from 1st of August 2021.
Yes. But this would imply that this won't have the cumulative effect after 1 year period. This is only for 1 year. 1 year is cumulative.
For 1 year without stoppage of increment without cumulative effect.
Further cumulative.
So therefore, you are trying to submit that after 1 year there will be cumulative effect.
After 1 year, this will not have any, as per this penalty, it will have a cumulative effect for the first period, first 1
No,
year.
there are two aspects. One is stoppage of increment,
Right.
another is cumulative effect.
Right.
Now, is it your case that no, it is not a case of there is no ambiguity in the punishment order? This is one way to interpret this order. That yes, it is a case of stoppage of increment, but without cumulative effect for 1 year. After 1 year, there will be cumulative effect. Is it your case?
My case is that this punishment has been the punishment order says stoppage of increment without cumulative effect for 1 year. But after this 1 year period has already expired. This stoppage of increment which has been stopped has not been restored, so it is continued. Therefore, it has been given cumulative effect even beyond 1 year. And my lord, in the standing order, the penalty, the stoppage of increment comes under major penalty, which says only stoppage of increment. That would mean, my lord, stoppage of increment with cumulative effect for the rest of my career.
Then you need to approach the appropriate court having jurisdiction with regard to for clarifying this
This has been
part.
clarified at page 22, my lord.
That is not related to your promotion,
No.
but because the root cause is this punishment order.
This has been clarified.
Now,
at page
if the
22.
punishment order you want to seek a clarification from the court, then that clarification needs to be made by the court having territorial
My lord, I
jurisdiction.
am not disputing the clarification already given in page 22. This says, my lord,
Yes, what clarification is given?
My lord, as such, the order of penalty dated 28/9/2021 is defective to the extent of this full, this whatever is under the quotation without cumulative effect for 1 year. This total code.
Then what is the effect?
This will go.
It is defective to the extent that without cumulative effect for 1 year.
Yes.
Then what is the result?
So only stoppage of increment. That is what has happened to me. And that is what the penalty or
Hence,
the standing order
proposal is
says.
returned for further necessary action at the meeting. No, hence the proposal is returned for further necessary action at the area level.
Yes.
So what action was taken based on this?
I have not been restored. That I have stated that in my petition that my increment, which has been stopped for 1 year, that has also not been restored after 1 year. So what they have done is only stoppage of increment, not nothing beyond that. They have actually correctly applied the penalty as prescribed in the standing order.
It is defective to the extent of without cumulative effect. No, according to you, what was the then? What is the punishment? Exact punishment.
This is the standing order. Well, kindly have a look at the first line on that page.
It is it is not made clear to this court.
But kindly have a look at the standing order.
Because this is a very cryptic clarification. So if you require a detailed clarification, then you need to approach the appropriate court.
The clarification granted by the respondent.
Today, to facilitate your promotion, court will not clarify your punishment order.
I'm not inviting. The clarification given by the respondent read with the conduct of the respondent and the standing order.
Which court will decide this? Because it is completely related to your punishment order. If your punishment order is not appropriately corrected, question of your further prospect of promotion may be impacted.
My submission is that, my lord, this clarification note, my lord, takes out this without cumulative effect for 1 year. This phrase from the penalty order, and if that phrase is taken out, my lord,
it says that it is that as such the order of punishment is defective to the extent of without cumulative effect for 1 year.
Yes.
Hence, the proposal is returned to further. What was the subsequent decision taken by the authority based on this clarification that without cumulative effect for 1 year is defective? And this clarification was made far back on 10th of April 2024.
Yes.
Now, thereafter, what was the decision taken by the authority?
My lord, written decision has not been communicated to me, but that they have not restored my increment. Therefore, my lord,
so for which you have to approach the Jharkhand High Court.
My lord, kindly for once, my lord, kindly seize the standing order.
For that, today I cannot pass an order facilitating your transfer unless until this grey area is made clear, is explained.
Very well, then, Lord, may I submit this, my lord?
This court cannot iron out the creases.
Well, even if the penalty order remains as it was on the date of passing of the order at page 18. My lord.
Because the entire proceeding was in Jharkhand.
Yes.
Now there is a subsequent clarification made by the authority relating to your punishment order. And it was sent back to the proposal is returned further necessary action in action at the area level.
Well, that my lord, BCCL is there, that they can say what they have.
How I can direct? BCCI is BCCI's role is only confined to promotion, not your punishment order. Otherwise, you could have preferred an appeal if the appellate authority is there seeking clarification.
But I preferred an appeal. Appeal was rejected. Appeal was rejected. That I have pleaded in page 8. My lord, the standing order.
Who is representing BCCL? So in BCCL, what is the effect of this punishment?
But effect is the lordship on the date of punishment lordship 1 year lordship. Clearly mentioned in the order of the disciplinary lordship as well as the order of the appeal lordship. That order has never been challenged lordship. If your lordship kindly comes.
So effect of this punishment order is not beyond that.
No, only 1 year.
So let me record this. If it is that on instruction he is submitting on behalf of BCCL, that effect of this punishment order is effect of punishment order dated 20th September 2021 is for a period of 1 year. Then there is no impediment in considering your case relating to promotion. Yes.
And that is why, Lordship,
On
that
the,
is-
on one hand, they are submitting it for 1 year, and the other hand, they are not
No,
restoring.
court is recording this order on their submission.
Lordship,
And court will also, he is also submitting based on this instruction. This is a letter dated 8 June 2022. So today, what is your stand?
That order passed during the punishment period. So by punishment period, there is.
Now, what is the position? Is there any difficulty in considering petitioner's promotion?
Next time.
This clarification is, well, he is relying up.
Where is such letter?
Can you see page 33? Can you see?
No, he is relying upon
Page
a
33.
2022 letter, my lord, but this clarification is of 2024.
Page 30.
Can you see page 33? This letter was issued, Lordship, on 26 December 2024, Lordship, issued by the PCJ. Please refer to your representation dated circumstances requesting for promotion from non-executive grade to E1 grade. In this connection, you are advised to apply for the above post after advertisement of politically. Now, we come to page 18, Lordship. The order of the disciplinary authority. Lordship, kindly come to page 18:18, Lordship. This is the order of the disciplinary authority, Lordship. In the bottom portion, last paragraph. Now therefore, all project officer come disciplinary authority. Ena Colliery as hereby impose the penalty stoppage of implement without penalty effect for 1 year with effect from 1/8/2021 for 1 year.
No, this was subsequently clarified.
Lordship,
Page 22.
Lordship, this is an internal note sheet, Lordship. How internal note sheet?
Come to page 22.
Lordship.
Under note 11.
So this is the internal note sheet, Lordship. Neither this chief manager.
As such, the order of punishment dated so and so is defective to the extent of without cumulative effect for 1 year.
Lordship,
How it is? Why then after such clarification was offered, then what would be the appropriate order relating to punishment?
This chief manager personal Lordship, neither he was the disciplinary authority nor he is the appellate authority, Lordship. How the note sheet come before this court, Lordship, I don't know, Lordship. It is the internal note sheet of this department, Lordship. And this person is not only the involvement of the disciplinary authority as well as the appellate.
So therefore, your specific stand is this, that the effect of this punishment order is for a period of 1 year. Now there is no difficulty in considering petitioner's promotion.
So can you see page 33? That is why the PCJ of
Then let me clarify it. Issue. Matter ends.
that is the PCJ already
Writ petition is heard in presence of the learned advocates representing the petitioner, comma. Bharat Coking Coal Limited and Coal India Limited. So, by presenting this writ petition, an apprehension has been expressed by the petitioner based on order of punishment dated 28 September 2021 and subsequent clarification offered by chief manager within bracket personnel is Bharat Coking Coal within bracket personnel Bharat Coking Coal Limited. Clarifying the effect of punishment of state punishment order dated 28 September 2020. Stop. According to the petition, next paragraph. According to the petitioner, if this clarification dated 10th April 2024 is accepted, effect of punishment of stoppage of increment would continue till the retirement of the petitioner, resulting in denial of right of the petitioner to be promoted to the next higher cadre. Stop. Next paragraph. However, learned advocates representing Bharat Coking Coal Limited and Coal India Limited have jointly submitted that considering the order of punishment dated 28 September 2021, as well as clarification offered by Chief Manager within bracket personnel, Bharat Coking Coal Limited, dated 10th April 2024, effect of punishment will not be stretched up to the end of tenure of the petitioner. Therefore, after completion of 1 year on passing punishment order dated 28 September 2021, there is no impediment in considering promotion of the petitioner in accordance with law. Stop. In this regard, a letter dated 26-31 26/31 December 2024, issued by Deputy General Manager within bracket P/EE close bracket, addressed to the petitioner, which is at page 33 of the writ petition, is relied upon. Next paragraph. On perusal of said letter at page 33, it appears petitioner was advised to apply for promotion to the post of non-executive grade E1, capital E-1. Stop. Next paragraph. Considering the submissions made on behalf of BCCL and Coal India Limited, it can be inferred that the effect of punishment order dated 28 September 2021 cannot be stretched beyond 1 year from the date of issuance of such punishment order. And as such, petitioner is entitled to be promoted to the next higher grade in accordance with law. Stop. Therefore, the apprehension which is expressed by the petitioner by filing this writ petition is not found to be well founded or is not well founded. Next paragraph. Hence, the writ petition. Next paragraph. With the aforesaid clarification, writ petition stands disposed of urgent. Take back your rules. These are not required. Eight শুধু required.
Item number 8.
Your Lordship, item number 8, 9, 10, Your Lordship. Same matter. Thank you.
6 centimeters. Yes,
Your Lordship, I have
petitioner should be considered as a fit candidate in terms of height as per the guideline. If it is 169.5, it should be rounded off to the next higher centimeter.
Your Lordship, as per Your Lordship's last direction, Your Lordship, I have served the SSC who are supposed to bring the instructions from their record. I have mailed them. They have sent me this instruction through mail and by post that they are not the answering respondent. The answering respondent will be CAPF as they are the recruitment appropriate authority, Your Lordship. Your Lordship, kindly next direction may be passed accordingly.
So that court does not want to enter into this. Court wants clarification from the department. So if it is not SSC, then obtain instruction from CAPF.
Yes, Your Lordship, direction.
Copy देना। ठीक है, तो कुछ original हो।
CAPF is the authority. SSC.
May I clarify on this point? This is the way they are passing the balls. But what happened? The CAPF come to an end after DME or RME.
No,
They
they
have
have
no-
they have indicated in paragraph 2C
Paragraph-
that these are the what are the zones where CAPF can give a copy.
Yes, I know this procedure. This the standard they
So
have.
if they have CAPF comes up with a report, where is the difficulty?
The difficulty is that, my lord, this I am indicating that this is the way to passing the ball. My lord, my learned friend has no knowledge about the thing that appeal has been preferred. And copy have been served upon us in this matter.
Appeal has been preferred against this order.
Yes.
Yes, Your Lordship, I
This
have
is
already
the thing, my lord.
submitted.
This way they are playing the balls. My lord, what happened? My lord,
Who has preferred appeal? CAPF has.
authority concern, yes. The
Or
nodal
SSC.
agency. Nodal agency, not SSC.
BSF.
Yes, Your Lordship.
BSF, no, my lord, there was a nodal agency of CRPF. CRPF preferred the appeal.
CRPF has
Yes,
preferred.
and the copy in this particular matter, copy has been served upon me. I have received. Although I have not given a note that I am not well, instructed to receive, but they have.
You are not aware that appeal has been preferred.
Your Lordship, in the last occasion, I have already informed this court. Maybe my learned friend has forgotten that already the appeal is pending before this honorable court, Your Lordship.
No, then I am the last. This is the last court which would have entered into the issue.
And
certainly not.
And moreover, my lord, this
This is not the practice of this court. That in pending appeal, if it is at the application stage, court will not enter into this issue.
But in the last occasion, I have
This is the wrong
submitted,
submission you are making today.
I have the case numbers also. I can show it
Nobody
before
has.
this court.
Nobody did submit this.
After
Don't make wrong submission.
I completely
If
apologize.
this would have been brought to the notice of this court that the appeal, why you did not indicate?
Last occasion,
You are not
I
aware
have
of.
no knowledge. I have no knowledge. Subsequently, thereafter, I received this.
What sort of
copy.
practice is this, madam?
Your Lordship, I don't know. I have
Court passed an order directing to file a report, and appeal has been preferred against the order against the last order.
Last order. Thereafter, they have complied
This
with
is
the order.
order dated 11 November 2025.
Yes.
Passed by this court.
No, my lord.
Oh, previous order.
My lord, 4th December 2024, the order was passed.
Absolutely, Your Lordship.
On 12th December, they have complied with the order.
But on this writ petition, no appeal, no 4th December order.
Yes,
Only
page-
order is
page
dated.
39. Page 39 of my writ application. I have a next. Page 39.
A separate writ petition.
No, Dhanapati Rai, my lord.
How it is possible? This is a writ petition of 27062, it is 10921.
Yes, 10921 is the continuation of earlier occasion.
In the previous round of
litigation.
petition, the appeal was
Yes,
preferred.
this
So
order
why
was
you are saying that against the order passed on 4th November, 11 November, an appeal was preferred?
no. That 4th November order, they have not preferred appeal. They have preferred appeal challenging the order date 4th December
Is
2024.
their right? They can prefer an appeal.
Yes, they have right. But what happened? I am saying submitting. But after that 12th November, they have complied with this order. They have asked me to present before the authority concerned. I present before there. They have completed all the procedures. Then the CAPF's a nodal agency come to an end that I have fit found in every aspect. Then on 13 the SSC.
What is the full form of PET?
PET means
primary.
No, matlab physical efficiency test.
Efficiency
test. I was measured 169.5 and more, but less than 170. I filed writ application before this honorable court in last round of litigation.
So when the appeal was preferred?
Just my lord, I think 10 days back they have filed, and 1 week.
Matter is appearing in the list.
No. No,
Your
my
Lordship,
lord,
this
appear.
appeal was filed on 24th of September 2020.
So based on this physical eligibility test,
efficiency
test, which was conducted in terms of the order date 4th December 2024, you are adjudged, your height was measured. Now that order, against that order, appeal is preferred.
Yes, thereafter the medical followed
Very
by
well.
medical.
So let me grant some time so that they can move the appeal.
My lord, in 1 year they do not.
No, not 1 year. Yes, 4th December 20.
Yes, 1 year, my lord. And moreover, I have been put the merit list, my lord, merit list, selection list with
Then file a report.
Yes, Your Lordship.
File a report. Who is the appropriate authority you are saying that CAPF will file a report?
Yes, Your Lordship, they have.
Well, CAPF in this case becomes functus officio because they are nodal agency conducting the PST, PET and medical. In my case, the PST, PET and medical has come to an end and found me fit. Then the step is coming that the names who found in the medical examination should be referred before the SSC for preparing their selection list candidate and recommendation. That stage is going on. My lord, my name has been put in the withheld list candidate.
No. Who has measured your height? Which authority?
CAPF or nodal agency, CRPF, Durgapur. Last.
So then CAPF should file a report. It's a case of measurement of height.
Yes, I have by this order I have been passed the height. In this case, rounding off is coming.
So who is to round it off? CAPF.
CRPF, right.
So then CAPF should file a report instead of SSC, because your height measurement was made by the CAPF.
Yes, height measurement, CAPF, medical, CAPF, they have done it.
So in their report, they should have rounded it, the CAPF authority should have rounded it off to next centimeter.
Yes,
that was not done by CAPF. So why report
appear.
will not be furnished by the CAPF?
Because my lord,
then based on this report on height measurement, then SSC will act upon.
That has been done.
But up to the extent of height measurement, yes, your name is included in the list of withheld candidates. Why? Because of the height.
No. I am putting this question to myself as to why my name has been putting in the withheld list. They did not disclose it.
No, but in my order, I have stated so. I have recorded so.
That last occasion, my learned friend, that submits that.
Physical measurement, on physical measurement was found that the height of the petitioner is 169.6 centimeters and 169.8 centimeters. Therefore, as per relevant norms, both the petitioners may be declared qualified for being appointed as constable jury.
Yes.
So it hinges on measurement of height.
Yes,
So let's say CAPF comes up with a report.
Ultimately, we are choosing the seniority. That is the thing. And by this time, 1 year will be complete and they will come.
Learned advocate representing representing the respondent authorities has produced or has placed a copy of the letter dated 14 November 2025 issued by Deputy Director Government of India, Ministry of Personnel, Public Grievance and Persons, Department of Personnel and Training, Staff Selection Committee within bracket ER, close bracket, Kolkata. And same is taken on record. Relying upon next paragraph, relying upon such letter dated 14 November 2025, it is submitted by the learned advocate representing the respondent authorities that as the issue relates to measurement of height of petitioners, report as per order dated 11 November 2025 needs to be furnished by the concerned authority of Central Armed Police Forces. Stop. Whether the CAPF is party? No.
CAPF is not party.
Not party.
I am
So
saying
make CAPF party.
no, my lord, respondent number 3 I have because they are the nodal agency, that's why.
Central Reserve Police Force, CRPF, not CAPF.
CAPF is the Central Armed Police Forces.
Yes.
That is no wings, my lord, including CRPF, BSF, ITBP, SSP, Assam Rifles.
There is no other, there is no authority named
CAPF is
CAPF.
a combined, my lord.
Central Armed Police Forces. Including all.
Including. And the nodal agency was there, that is the CRPF. That's why I made them party.
Stop. And nodal agency is the CRPF.
CRPF, conducting the PST, PET and medical.
কি বলছিলাম last semester? Petitioners. No, needs to be furnished by the concerned authority of Central Reserve Police Forces within bracket CRPF. Next paragraph. Hence, concerned authority of Central Reserve Police Force or a concerned authority of CRPF is directed to file a report as to why petitioners were not declared fit or not declared eligible in terms of their measured height for being appointed as Constable GD. In the form of affidavit by 10 days from date.
That will be the clock to go back because that already done. That last year order, 4th December order already they have it. In that order, that part has been exhausted.
Stop. In the report, it will also be disclosed as to why petitioners' names are included in the list of withheld candidates.
That will be the best.
Stop. Let such report be filed by 10 days from date with an advance copy upon the learned advocate representing the petitioners. List the matter under the same heading for further consideration. On 15th December 2020.
Same as order item number 8 and 9, 10.
Yes, let it be called on one after another.
Item number 9.
9 may please, Lordship, I am for the petitioner. But in this case, I have no instruction whether the appeal has been prepared or not till date.
9
Are you filing a similar letter? No.
No, Your Lordship.
But the issue is same.
Issues are same, Your Lordship. And
Order date also same.
এই issue. এটা সিঙ্গেল পিটিশনার করে দেবে, লেটারটা দেবে না, measurement of height আর ইয়ে করে
My lord, appeal has been filed in this case also. MAT number 1699, 1691.
2024 order.
25.
What you are, what
Appeal
steps
is
you are taking?
Complied with. The
Already
person
order has
gate-
been complied with.
Complied with. Gate
How long court
appointment.
will wait?
Yes, your lordship.
বুঝলে ওই লেটারটা কিন্তু এখানে থাকছে না আর সিঙ্গেল পিটিশনার সেম অর্ডার
Deeply obliged.
Item number 10.
10 also, my lord, same, my lord, I have not
Appeal
started whether.
has been preferred.
No, my lord, this appeal has been prepared and registered administration has passed on one order, but there is a defect. I have instruction, yes.
ডিফেক্ট ইন দ্য অ্যাপিল
Defect in the appeal. And if the the advocate on the court remove the same, place the matter before the court.
In the meantime, let them file a report. Single petitioner, same order.
Deeply obliged.
If honorable division bench passed an order, that will be brought to my notice for taking for passing
Further-
appropriate
further.
order. Next.
Deeply obliged.
Item number 11.
My lord, this says CRP height is 169.5 in remeasurement. That is in page number 14, my lord.
Who is appearing for the respondent?
My lord, Mr. Indrajit Dasgupta and Tapun Bhanjo is appearing for them.
But
I have
nobody is
served
appearing
notice-
today.
I have served notice upon them. And also to the.
Have notice, further notice, come back. Today, nobody is appearing. In their absence, no order can be passed.
My lord, the difficulty is that the examination with the DME will stop in the.
Well, not today. Sir, inform them. Next.
Item number 12.
My lord, item number.
But I am for the response.
My lord, I am for the petitioner. My lord, kindly consider the order passed by your lordship. Last August. Entire thing.
এনেছিস রোপা
রূপটা আপনার কাছে আমি পাইনি।
তুই মামলা করবি তুই রোপা পাবি
এই বলবে বলুন দেখি এন্টায়ার থিং রেকর্ড করা আছে।
Yes, ROPA 2020.
পাসনি রোপা
না রে বাবা তাহলে তো আমি-
তো তোর পয়েন্ট রাইট
আমার ঘর থেকে দিই।
Malad, kindly see the Malad definition, applicability, the first clause, Malad, applicability. Every employee of the company, including those,
Where?
Malad,
Where from your reading, it starts from, it is
Well,
dated
the-
30th October 2020.
yes, Malad, 20.
Then in order to evolve a proper, it's an object.
Yes, yes, yes. Malad, the clause, column 3, applicability. Malad, every employee of the company,
Not
including
column 3, rule 3.
Rule 3, Malad, I'm sorry. Rule 3. Every employee of the company, including those on deputation to other organizations who are in payroll of the company, as on 1st January 20, shall be entitled to fixation of pay in corresponding revised scale of pay as per Annexure 1 with effect from 1st 1/1/2016. Or if he or she enters the company service on or after 1st January 16 from the date of his joining of the company.
So there is no provision relating to notional benefit.
Notional benefit.
Actual benefit is given from 1st of January 2016.
No, with effect from 2016, those who have payroll in the company's payroll
The
on
petitioner was in the payroll.
payroll of, he has retired on 31st January.
So 1st January he is in service.
He retired on
31st January
31st January 2020. Now, prior to his retirement, whether he received the benefit under
Yes,
under
yes.
this revision of pay and allowances rules.
That will
2020?
be clear from
Yes.
page 18.
Wait.
Page 18.
Now Milord, so far
I am asking him
You
that prior to his retirement, whether the petitioner obtained this benefit under ROPA 2020.
no Milord, after it, because it is being delayed.
No, when petitioner was working, this petitioner retired
20
on 31st of
January.
2020. After that, it was promulgated.
Now Milord, come to page.
It was issued on 30th October 2020 after retirement of the petitioner.
Now Milord,
So therefore, petitioner is entitled to get the benefit at least from 1st of November 2020.
Yes, I'm not on that. So far leave salary is concerned, well, Lord, he is not entitled anything. Your Lordships kindly come to page 12 of 13, rule 30.
Rule 30.
Page 12.
Yes, my lord. 13.
Page 13.
Yes, 12 of 13, my lord, actually.
Yes. 12 of 13.
Yes.
Leave encashment
Yes.
at a time of, yes.
But existing rules for granting leave encashment facilities such and such on leave in calendar year will continue. Leave encashment for the employee on service on the basis of revised pay will be effective from 1st April 2020. So therefore, leave encashment is not entitled. Prior to that, he has retired. 1st January.
He was given leave encashment.
Yes.
He was paid.
Yes, that was paid, but no further.
Leave encashment further.
দিয়েছে ফার্দার
ভুল করে দিয়েছে রিকভারি করতে হবে
পেনটা দে তো
Now, when the petitioner retired on 31st of January 2020, then after that, from 1st of April 2020, petitioner was entitled to leave encashment.
It is effect from 1st of April 2020.
Petitioner was not entitled to get the effect benefit of this rule 30.
Yes.
It was from 1st of April. So excluding this leave encashment, other benefit
we have already given.
Eligible
Gratuity.
From 1st November 2020.
1st November 20. That we have extended. We have given.
Now interest you are required to on the revised benefit. Yes, come back at 2.
Interest. My lord, your lordships kindly excuse me too because I have on fixed matter. If your lordship,
let me see, come back. Yes, we are
item
considering interest on revised benefits as per ROPA 2020. Now you have brought to the notice of this court this ROPA 2020 relevant rules. First, Rule 3,
applicability.
which says that it is from 1st of January 2016. So therefore, petitioner was entitled to receive this benefit from 1st of January 2016. Now, petitioner retired on 31st of January 2020. So the benefits which has been granted to the petitioner after retirement, because
We have given, we have already given.
because this rule was implemented with a notification dated 30th October 2020. So if it is from 30th October, prior to that, there was no scope for giving such benefit. So therefore, entitlement of the petitioner comes on and from 30th October or from 1st of November 2020.
Yes.
But that benefit is to be counted from 1st of January 2016.
Yes.
That you have given. But your submission is this, that in connection with Rule 27, Rule 30, that leave encashment benefit was allowed as per ROPA 2020 revised benefit from 1st of April 2020, which petitioner is not entitled to, considering date of retirement of the petitioner.
That's my submission. Now I leave it.
Now, whether a revised pension payment order was given to the petitioner, issued in favor of the petitioner, it was paid.
Yes, Lordship.
When it was paid?
Page 90.
It was paid sometimes to
Page
25.
90. Page
It is
90.
it is being delayed, my lord. It is
Delayed. Page
that
90.
my lord I cannot say it is delayed.
My lord, may I submit one paper?
Just a minute.
But office order says, my lord, leave salary also. Perhaps, my lord, there is some.
What is XSTA excluding? Page 19.
Statutory deduction. That is
Statutory deduction, my lord, TDS.
So only difference is gratuity.
gratuity and leave salary. May I submit one thing, Lordship? Page 18 kindly.
Yes.
Page 18.
My lord is on page 18.
No, page 19.
Okay.
Page 18. Lordship, kindly see, this is the common notification circulated by the after 2020. My lord, may I read for your Lordship? Subject payment for differential amount of gratuity subject to selling limit and leave salary payable on account of implementation of ROPA 2020 to the employer of DPL, including employer of DPL deemed to deputed at WBACTCL, WBACTCL who had superannuated, resigned, died during the period from 1st January 2020 to 31st March 2020. Then, my lord, it is being
So you retired on 31st of January 2020.
So
So
I
you are
come-
coming during this period.
Yes. Then, my lord, it is being informed that the employer of DPL, including employees of DPL deemed to deputed WBACTCL, WSETCL who had superannuated, resigned, died during this period from 1st January 2020 to 31st March 2020 are entitled to get differential amount of gratuity and leave salary on account of implementation of ROPA.
Yes,
2020
I am not
as
denying his, my lord, entitlement. So far, leave salary is concerned, it is a common, it's a common notification. Those who have entitled. My submission is petitioner is not entitled. I am not saying it's a common notification.
But it is this notification is confined to 1st of January 2020 to 31st of March 2020.
Yes, 31st of March 20.
Who had superannuated, resigned, died during the period from 1st of January 2020
Yes.
to 31st of March 2020.
2020. I retired on
The
31st.
31st January 20. Therefore, he is entitled, we have given.
Now, why leave salary will not be given?
But leave salary as per ROPA, Rule 30.
Then why this was issued?
Well, it's a common notification.
Creating confusion.
Yes, it's a that's good.
Why this has been issued?
Yes. This should this shouldn't have been, my lord, issued.
But leave salary, it appears that you are not entitled.
Yes, that's
Revised
what-
leave salary.
Yes.
Why I am telling you?
Because
that
leave
in
salary has
terms of-
already you have extended, revised.
In terms of ROPA rules, Rule 30, it is specifically provided.
May I take?
It will be effective from 1st April 20.
Leave encashment for the employers whose service in the basis of revised pay will be affected from
First April.
Existing rules for
That is there,
leave
because you have already retired 31st January. Otherwise, those who have entitled, we are not on that.
encashment for the leave encashment for the employees on service, employees on service.
Yes, not
On the basis of revised pay will be effective from 1st of April 2020. Prior to that, you retired.
Yes, then this
And he has
rule will be applicable to me
We
from 1st April.
So that's why this rule is will not help you
Yes.
in the matter of leave encashment.
That's my submission, my lord. Your lordship.
Had you been in service after 1st of April 2020, you were entitled.
Yes.
But since you retired on 31st of January 2020,
Yes.
it does not come in your aid so far interest is concerned. Whatever was paid, because in terms of this revised pension payment order, you have been paid the differential amount of gratuity, but leave salary was not paid to you. Why? Because this is not applicable so far the petitioner is concerned, which is confined to payment of leave salary.
Subject to your lordship correction, this is my submission and I state that I have been paid the leave salary.
No, leave salary you have paid because he's entitled leave salary. Difference of leave salary.
When the first pension payment order was paid.
First
When
payment.
a pension is not there, my lord. In the DPL employee.
DPL there is
So when the first pension payment was when the pension was initially paid after superannuation on 31st of January
there is
2020.
It was paid to me.
No pension.
Provident leave salary and gratuity was initially not paid to me. I came up before this honorable.
The deal.
This honorable court directed principal amount of leave salary, gratuity and leave salary
With interest.
That is page 14.
That is being paid. My lord. That was paid.
I am admitting that is paid.
That is page 14, order dated 15 November 2022.
Yes. That has been complied.
That was paid.
That was paid. Thereafter, my lord, this page 19 was issued.
So why you did not pay for payment of leave salary in terms of the revised pay scale? Because at that point of time, this notification was in force.
Page 18.
No, please answer the query of this court.
Yeah.
Why at that point of time you did not pay for revised leave salary?
May I submit? Page 18 was issued only on 10th January 2025. Kindly see.
Your entitlement comes from, I am not with page 8.
I am on expect.
Your entitlement comes from revision of pay and allowances rules 2020. Why you have not asserted your right?
My lord, this general notification.
So whatever was paid, which was required to be paid or which was payable to you prior to implementation of ROPA 2020.
My lord, as per the order of this honorable court, my principal amount has been paid. My lord, that was that.
Now, at the time of disposal, the interest was granted.
Yes.
6%.
6%.
6%.
And that was paid also.
Yes. Petitioner was an employee of Durgapur Projects Limited, who retired on superannuation on 31st January 2020. So, after superannuation of the petitioner, within time, retirement dues were not released in his favor, which prompted the petitioner to file a writ petition being WPA 23600 of 2022, which was disposed of by a coordinate bench with the order dated 15 November 2022.
May I take back your rules? I'm grateful to you.
15 November 2022. Stop. Video order dated 15 November, by order dated 15 November 2022, respondent authorities were directed to release return dues along with 6% interest. Within stipulated time. Stop. It is next paragraph. It is submitted by the learned advocate representing the petitioner that in terms of the order dated 15 November 2022, return dues along with interest was paid to the petitioner, but revised benefits, revised return dues in terms of the Durgapur Projects Limited, within bracket revision of pay and allowances close bracket rules 2020, which was issued with a notification dated 30th October, which was implemented with a notification dated 30 October 2020, was not paid. Stop. Same was paid. So revised benefit was paid by issuing subsequent order dated 24 January 2025, and petitioner has approached this court with the present writ petition claiming interest on revised benefits which was payable to the petitioner in terms of ROPA rules 2020. As per provisions of the said rules. এবার উপরে যে রুলসটা বললাম না, দুর্গাপুর প্রজেক্টস লিমিটেড ডিভিশন অফ পে এন্ড অ্যালাউন্সেস রুলস 2020, ওখানে হিয়ারিন আফটার রেফার্ড টু অ্যাজ রোপা রুলস 2020, ক্লোজ ব্র্যাকেট কোট আনকোট। Next paragraph. It is submitted by the learned advocate representing Durgapur Projects Limited that as per Rule 3, revised benefits are allowed in terms of ROPA Rules 2020 on and from 1st January 2016, but said ROPA Rules 2020 came into force with a notification dated 30th October 2020. Stop. Placing reliance on Rule 30, it is also submitted that petitioner is not entitled to claim interest on revised leave encashment benefits, as such benefits were allowed to those with effect from 1st April 2020, whereas petitioner retired on 31st January 2020. Next paragraph.
Sorry, not only interest, leave salary.
Yes,
Your lordship direct interest.
Leave encashment benefits, I have said.
That your lordship kindly.
Nothing is payable in terms of ROPA 2020.
That your lordship.
Because it came into effect,
Yes,
from
April.
1st of April 2020.
But kindly indicate
that I have said. Next. Considering the provisions as contained in ROPA 2020 rules, it appears in terms of Rule 3, revised benefits were allowed from 1st of January 2016, but revision was effected pursuant to notification dated 30th October 2020. Therefore, petitioner was entitled to get revised benefits under revision of under ROPA rules 2020 on and from 1st of November 2020, not before that. Petitioner retired on superannuation on 31st January 2020. Therefore, next paragraph. Therefore, petitioner is entitled to receive interest due to delayed payment of revised benefits as per ROPA rules 2020 on and from 1st of November 2020, not prior to that. Next paragraph. Accordingly, concerned authority of Durgapur Project Limited is directed to pay interest at the rate of 6% to the petitioner on revised benefits which was paid to the benefits which were paid to the petitioner as per ROPA rules of 2020 by 8 weeks from the date of communication of
Well, revised means your lordship kindly make it clear. Only
Please wait.
gratuity.
Please wait.
Oh,
Please wait. By 8 weeks from the date of communication of this order. Stop. Next paragraph. It is clarified that petitioner is not entitled to receive. Now, it is clarified that since petitioner is not entitled, or petitioner was not entitled to receive revised leave encashment benefits in terms of Rule 30, as such benefits were allowed from 1st of April 2020, whereas petitioner retired on superannuation on 31st of January 2020. No interest is payable, comma diye, no interest is payable on leave salary, on benefits, on benefits under leave, or no interest is payable on leave encashment benefits. Next paragraph. Writ petition has disposed of urgent.
Grateful to you. Grateful. Well, this ROPA should be kept to record.
Item number 13.
For the petition in this matter. The matter was previously taken up before your lordship on the last day.
Just in
my lord.
Yes.
Now, my lord, he is, my lord, charge seated based on the investigation carried out by the CBI. Now, my lord, basically, I am praying for the stay of the disciplinary proceedings till the conclusion of the CBI investigation, CBI trial, my lord. Now, if your lordship kindly come, the charge sheet at page 28. Page 29 is, my lord, the statement of articles. May I read, my lord? At top, it has been revealed during the investigation carried out by CBI SCP Dhanbad on such and such. Sri Sitwal Bauri, that is the Writ Petitioner General Assistant.
Who has issued the charge sheet?
Charge sheet has issued, my lord, the agent of the concerned colliery.
Just a minute. It is within the state of West Bengal.
Inquiry
area colliery.
No. Inquiry is here. Inquiry is conducting by the inquiry officer.
Where?
At Asansol. I am coming to that, my lord.
You are staying in state of West Bengal?
No, I am staying at the Dhanbad. The charge sheet was issued from Dhanbad. I was posted at Dhanbad, but inquiry officer is from the headquarters, that is at Asansol. Venue of the inquiry is also situated at Asansol, and inquiry is being conducted at Asansol. I am challenging the, my lord, inquiry, so my lord.
Yes.
I am not challenging the charge sheet. Now, page 29, my lord. It has been revealed during investigation carried out by CBI ACB Dhanbad on such and such that Sri Shitol Bauri, that is the Writ Petitioner, General Assistant Khodia Colliery, Mugma Area ECL, in connivance with one other official of Khodia Colliery, Mugma Area ECL, allegedly committed gross irregularities by accepting illegal gratification of rupees 15,000 from Sri Umesh Prasad Singh, such and such, the then electrician of the such and such colliery, NIRSA, ECL, for processing the document of retirement benefits like provident fund, gratuity, pension, etc. of Sri Umesh Prasad Singh on the date of superannuation of Sri Singh, that is on behalf of dealing assistant PF pension of Khodia Colliery of Sri Arvind Kumar Rai. So now, my lord, there was
just a minute. Yes.
Now, my lord, very basis of the issuance of the charge sheet is the CBI investigation. Now, if your lordships kindly come, the page 84, 53. 53, my lord. This is the list of witnesses cited by the CBI in their charge sheet in the criminal matter, my lord. All are same. Now, if your lordships compare with the charge sheet issued by the department, that is at page 32, side by side, my lord, page 53. All the witnesses are same.
It is the page 53 is the witnesses in connection with CBI case.
CBI case. Now, page 32 is the witnesses in, my lord, the departmental proceedings. My lord, may I read, my lord, so that your lordships may compare,
Just
my
a
lord?
minute. At present, you are under suspension.
I have been, my suspension is revoked and I am working my normal duties.
So page 53 is are the witnesses
of
in connection with CBI case.
CBI case.
Yes, then in
Page-
the disciplinary proceedings.
Page 32, my lord.
But the issue is same. Issue is completely same. There is no additional charge in the
there
charge
are
sheet.
additional charges, my lord. If Mr. Ghosh finishes, that's why
There are additional charges.
Additional charges means, my lord, I will demonstrate, my lord, before your lordship, what are the charges before the CBI court and what are the charges in the departmental proceeding. It's true. It has emanated from
It's a
the
case
section
of bribery.
Bribery.
Now accepting bribe. Now that is the whole issue.
My lord, that is
Now
the whole
today,
issue, but-
if in the inquiry proceeding petitioner discloses his defenses, then that he will be prejudiced in the criminal
But
proceedings.
there are judgments, my lord, as following from your lordship. There are judgments, but there are other judgments too, my lord, that I will show before your lordship, my lord. Place before your lordship. Let Mr. Ghosh places his case. So I didn't interrupt when he was placing.
Yes.
So
now
unconditional stay for long, my lord. We do not know when CBI case will end up, my lord. No one knows. So there are certain criteria, as your lordship knows. It starts from the Captain Paul Antony case, but it laid down certain criteria. So I will come to that, my lord.
My lord, thereafter, my lord, the inquiry officer has been appointed from the headquarters. Now inquiry is conducting here. I have wrote a letter to them so that, my lord, they may not, my lord, proceed with the inquiry till the criminal case is pending.
When where is a notice relating to inquiry?
Page 57, my lord. This is the first notice issued by them for appointing of the inquiry officer and, my lord, the management representative from the headquarters.
Yes, this is relating to appointment of inquiry officer.
Inquiry officer?
When the inquiry officer
Yes.
fix the date of hearing.
My lord.
Date of inquiry.
Page 60, my lord.
So on 7th October you appeared.
No, thereafter, my lord, page 62.
No, I'm asking you, on 7th October you appeared.
My lord, I wrote a letter to them, my lord, so that they may, my lord, stay the proceedings, my lord. I have annexed the
7th October inquiry was held.
Yes.
Inquiry was not held.
What happened? He issued a letter stating that it's not that the inquiry may.
Yes, yes.
He issued a letter stating, my lord, I must say, my lord, there are two accused in the criminal case. Here also, my lord, two persons in the disciplinary proceedings. Will show from the record, and both of them issued same letters. That due to their wife's illness and something like that.
Wife's illness?
They
Yes.
are unable to attend. So it was, my lord, postponed.
Postponed.
Thereafter, another date, they didn't appear. On the last date, my lord, they appeared. They, my lord, they appeared. And thereafter, my lord, they filed the case, my lord, on the last occasion. I said, my lord, so it's not proceeding right now.
The very initial stage. Now, my lord, the state of my lord coming to the judgment because your lordship already knows the fact. My lord. কপিটা দিন না my lord? বলে দিচ্ছি বলে দিচ্ছি
Just right.
First, my lord, I have, my lord, relied upon a unreported decision of Bipin Kumar, possibly my learned friend is appearing. Yes. The interim order, my lord, pending before your lordship in a similar matter and Mugma area's case, my lord. May I place entire order or your lordship will, my lord? First order of my lord Justice single bench judgment, very recent judgment and pending, my lord, returnable date before your lordship is on in very 26th, my lord. My lord Justice Rai has passed this order, my lord, earlier determination. আরেকটা আনরিপোর্টেড দেখাবো আসলে সরি ওটা আমার কাছে এক্সট্রা কপি নেই সরি দাদা নেই আমার কাছে আমি ভুলে গেছি আমি তো বলেছি আমি তোমাকে দিয়ে দেবো এখন আমি পড়ে তোমাকে দিয়ে দিচ্ছি এখন এই আমার থেকে দেখে নাও ওই সেম সেম লাইনের কথা
Yes, first order.
First one. Next
Similar issue.
Similar issue. Now, page 6, my lord. This is the order, my lord, of the similar matter, similar issue. Passed by my lord Justice Arijit Banerjee. This is unreported. I am sharing the copy, my lord. May I read first one? Yeah. WP number 29425W of 2024.
Page 10, relevant portion.
Page 10, my lord.
Just a minute.
নামটা কি আছে পার্টি গৌতম মন্ডল ভার্সেস ইস্টার্ন কোলফিল্ড লিমিটেড
That is the principle.
My lord.
If the disciplinary proceeding continue along with criminal proceedings, the writ petitioner would be compelled to disclose his defense
ma'am. Yes,
before the inquiry officer, and the process would be jeopardized in his defense in the criminal trial.
Get full to us.
That is the
Yes.
moot issue.
Now, page 12, my lord. This was the limited entry order. This was the limited entry order. Thereafter, page 12. Extension the same matter, my lord. Subsequently, the entry order is extended till disposal and till that the matter is pending, my lord, before Lordship's court. Now, another judgment, page 13, my lord, passed by my lord Justice Dipankar Datta, as his lordship then was. Is reported in 2013 SCC Online, Calcutta 15456. Firoj Ahmed versus Union of India.
Which paragraph you are relying upon?
My lord, this is the last paragraph because it's a long judgment on the same issue. That's why I'm not reading, my lord. Page 18, my lord. Page 18, paragraph 19.
Yes.
Now, my lord, page 19 is a Paul Antony's case, my lord. Paragraph 22, my lord.
That Justice Banerjee has
extended the interim order, that matter.
No, Justice Orijit Banerjee, while passing an interim order,
Paul Anthony has
considered paragraph
yes,
a relevant part of Paul Anthony's case.
yes.
Paragraph 22.
Yes. That has been, this is a basic judgment, my lord.
This is the first judgment.
First judgment on the field. Paragraph 22. Page
Diamond mine in Karnataka.
My lord. And GM Tang, I'm coming to that, my lord. Page 31, the Paul Anthony's judgment.
Paragraph 22.
Paragraph 22. 22, Roman 1, Roman 2. If the departmental proceedings and criminal cases are based on the identical and similar set of facts.
Departmental, just a minute.
My lord. Roman 2, my lord.
Yes.
My lord, next judgment as page, my lord, 36. This is a very recent judgment of 2024. 2024, volume 1, SCC 175.
Yes.
This is a Ramlal judgment, my lord.
Paragraph
7, 12, 30 and 34.
30 and 34.
My lord. 7, 12, 30 and 34.
Yes.
The next judgment.
Now let me hear the other side.
Yes. Last judgment, my lord, only one, sir, of my lord Justice Dipankar Datta in this
Yes.
page 50, my lord. The 2025 SCC Online SC 890. The judgment of my lord Justice Dipankar Datta in Supreme Court.
Yes.
Paragraph 14, 25 and 47 is very vital.
Yes.
Well, before I start, my lord, the matter on merits, my lord, on the moot issue, my lord, may I only indicate first I would like to, my lord, have this one judgment, the order which Mr. Ghosh has cited.
First, show me judgment will come later.
No,
First, show me
what I want.
that the charge which is being considered in the criminal proceedings is different from the charges leveled against the petitioner in connection with DCPA proceedings. Then judgment will come later.
I'm not showing my judgments, my lord. Only one thing I.
No, whatever may be the judgment, I will permit you. But first, show me that the charge, criminal charge, is different from the charge leveled against the petitioner in connection with DCPA.
My lord, my lord. First, my lord, kindly take.
First, you have to narrate the fact based on which judgment ratio of the judgment will be applicable.
Kindly come to page 41 first. This is the charge sheet in the CBI case. Page 41. And what are the charges?
Where the charges are delineated?
My lord, column 4, my lord, if your lordship sees from top 04.
Page 41.
Page 41. Final 3 is final report, charge sheet number such and such, dated 30th May 2025. Thereafter 4. It's under section 7 of the Prevention of Corruption Act 1988. And my lord, read with section 61 of the BNS 2023. Now section 7 says, what is section 7, my lord? It deals with offences relating to public servant being bribed, and 61 of the BNS is criminal conspiracy.
Where the imputation of charge in the charge sheet?
Yes. Now I come to that, my lord.
Brief facts. Just a minute.
Page 30.
Page 44.
Page 30. Where?
No, criminal charge.
Criminal charge. Yes.
same issue. Come
So
to page
that's why,
48.
that's why I wanted to resort to the one judgment
Identical.
first.
What it is a settled position.
My
There is
lord,
judgments of the
okay, allow
Supreme
me, my
Court.
lord. Yes, lordship is correct.
First demonstrate that there are additional charges
That's
or
why I
allegations.
wanted to show, my lord.
Yes.
What are the additional charges and what are the laws, my lord? As your lordship knows, my lord, it's not only it's arising from the same charge, same fact, the charges and the evidences are also same. That if it is same, then there should be or there has to be a stay. Now, my lord, that's why I showed, my lord, what are the charges in the
I have seen the charges. You
Section
show
7.
me that in your disciplinary proceedings there are additional allegations.
Come to page 30 at 31. Bribery is one of the charges, and the other charges too, my lord. And it's 31.
Yes, 30-31.
Yes. First is clause 26.1 of the certified standing order. Theft, fraud, or dishonesty in connection with employers.
Where from you are reading?
Page 31. 30 at 31.
Where from you are reading? Tell me.
Last,
30 or 31?
31.
Yes.
Last paragraph.
Yes. Thus?
Last paragraph.
Yes, read it.
Thus, the aforesaid act of Sri Shital Baudi, UM number such and such, General Assistant Khodia Kuli Mugmeria for acceptance of illegal gratification other than legal remuneration, bribe of rupees 15,000 in connivance with Sri Arvind Kumar Roy, Clerk Khodia Kuliri Mugmeri ECL from the complainant Sri Umesh Prasad Singh, son of late Chote Lal Singh, the then electrician of Khodia Kuliri Mugmeria Nirsa ECL for processing the documents of retirement benefits like Provident Fund, gratuity, pension, etc. of Sri Umesh Prasad Singh constitutes misconducts and hereby charged under clause 26.1, 26.2, 26.5, 26.38 and 26.41 of the certified standing orders in respect of Eastern Coalfields Limited, which read below. So what are the charges? Now it comes, my lord. First, 26.1.
Fact is, what is
Fact
the
is
basis?
to be.
Fact is not established by the dint of prosecution witness in connection with criminal proceedings. Everything goes so far disciplinary proceeding is concerned. You may have made certain other allegations or you may have made certain other charges, but it hinges on the fact of accepting bribe, which is the subject matter before the CBI court.
Now, may I, my lord? Subject to, my lord.
Under the service rules, you may have charged under the clauses. Now you will rely upon this clause 26.1, 26.2, 26.5. But what is the basis of this fact? Basis of the fact is only one, only singular basis.
Basis of
That
these
is
charges.
Petitioner accepted bribe from one Umesh Prasad Singh on behalf of Arvind Kumar Roy. So that is the whole issue.
But my lord,
if there is no difference in the facts, then you may have applied rules relating to initiation of proceedings, but the issue is absolutely same, identical. If issue is identical, I am bound by the
I will also show some
of
judgments.
our High Court and the Supreme Court.
I will also show some judgments, my lord. First, I will take, my lord, your lordship with all this Paul Antony's
Sure.
judgment.
Sorry.
My lord,
enough is enough.
No,
Sorry,
I
yes, yes.
place my judgments.
Yes, yes.
Allow me to place my judgments, my lord. Allow me to place my judgments now. My lord, kindly allow me
That
to
is
place my
hard in
judgments.
presence of the learned advocates representing the petitioner.
No.
And
my lord, kindly allow me to place my judgment.
Eastern Coalfields Limited. Being the principal respondent. Stop. It is demonstrated before this court. No, it is submitted by on behalf of the petitioner that a charge sheet was issued on 4th August 2025. Again, on 4th August 2025 against the petitioner, who is a general assistant of Khodia Colliery, Mugma area, ECL. Based on fact that petitioner accepted a bribe of rupees 15,000 from one Umesh Prasad Singh on behalf of Arvind Kumar Rai, clerk of aforesaid colliery, for processing retirement dues of